Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey, people represented by Ms. Clark and Mr. Goldberg. And we had a preliminary matter to settle before calling the next people's witness in the nature of an objection regarding certain content of the statement. We're now joined by Mr. Darden. Good morning, counsel. All right, Mr. Douglas, I've reviewed the Estes case, 82 Calap 3rd, 509, Estes, E-S-T-E-S. And I've also reviewed the memorandum of points and authorities filed this morning by the prosecution and specifically by Ms. Lewis.
This morning we found a couple of additional cases that we wanted to cite to the court and counsel. I apologize for not having them in the points and authorities. One was People versus Bowe at 1 Cal 4th, 281, and the relevant discussion starts on 302. And the other case is also a California Supreme Court case. People versus Pride at 3 Cal 4th, 195. Relevant discussion starts on 234.
Critical, Your Honor. I've only this morning had a chance to briefly peruse the memorandum that was submitted. I have not, of course, had a chance to review these cases or their applicability to the issue at hand. I expect that my cross-examination of this witness is going to last for at least a couple of hours. I would like, before I am required to respond with any in-depth analysis, to at least be given the chance to review these cases, to examine them. I believe, Your Honor, that the statute about which we concern ourselves is clear. I offered a parallel to that statute in the Estes case, though it is not the exact statute. I do think that the reasoning of that statute is very applicable to the issue at hand. I do think, Your Honor, that there's another threshold issue that is raised, and that is one of 352 as to the probative nature of the substantive statement, even in any excised form. I think that there is a tremendous question in the scientific community as to the predictive nature of certain statements about which we concern ourselves. They are not predictive of events that may have occurred in the past or predictive of things in the future, and that entire issue is one that is most properly the subject of expert testimony. There is the very strong likelihood that it is going to necessitate confusing of issues, the undue use of additional time, the certain calling of different witnesses who might be experts on this area, who might then be able to place these statements, even in its excised form, in a greater understandable context for the jury. I offer to the court my opinions, as I did at sidebar, that I cannot properly address the circumstances in which the statement was allegedly given, and for the record, we will deny that the statement was even made, and we will strongly challenge the factual predicate for the giving of the statement, such that we would think it proper that there be a hearing consistent with Evidence Code 403, laying the foundation for the preliminary fact that, in fact, this statement was even given. For all these reasons, Your Honor, and given the fact that I have not had an adequate chance to properly cross-examine or to properly review these cases, that we be allowed to examine this witness, because I'm ready to examine this witness on matters other than this disputed area, that I be given adequate time to do my own independent research given this new information, and that the witness be recalled later in the trial, or that that portion of his testimony be held until later.
Mr. Goldberg? Mrs. Robertson, let me ask you to, if you would, make 2 photocopies of the relevant portions. Thank you.
Your Honor, apparently the defense has been aware of the statement since January the 22nd. And obviously, if there were any issues as to legal admissibility, there was plenty of time to research those, to address those today. Obviously, the prosecution wants to put the statement on as part of Mr. Shipp's testimony. There's no reason for breaking up his testimony and having him come back later after counsel has had an opportunity to do further legal research. Does the court want the prosecution to address our theory of admissibility now and the issues regarding the statement?
Yes.
Okay. I'd first like to start out with a discussion of the relevancy of the statement, because I think counsel seems to be suggesting under 352 it's not admissible. And any discussion probably should start with an issue of why is it probative, why is it relevant? And then I'll get into the issue of the polygraph aspect of the statement in the second part of my response. As to the probative value of the statement, Your Honor has ruled already in the context of the domestic violence evidence that the prosecution is entitled to put on evidence in this case, and apparently spend a significant amount of time doing so in what I think the court characterized as being the equivalent of several misdemeanor jury trials. We are entitled to put on this evidence for the purposes of showing the defendant's mental state and showing his intention at or around the time of the murder.
But the controverted statement, though, is the very next day. So, I mean, we're out of the category of domestic violence, wouldn't you say?
I just want to tie it into why it is relevant in the context of all of the evidence that the court has allowed. The purpose of that evidence is to allow the jury to infer something circumstantially about what the defendant was thinking at or around the time of the murder, what his mental state and his motivations were. It's circumstantial evidence because the inference, the chain of inferences, is that we can determine from his conduct what his intention, what his mental state must have been. The evidence pertaining to Mr. Shipp differs in only one respect, and that is that instead of being circumstantial evidence of his intent and his mental state, it's direct evidence, because it's him saying, this is what I've been thinking, and from the context of the statement, it was over a period of time. Now, the distinction there between direct and circumstantial isn't particularly important. What I would suggest to the court is important is the way that the respective sides have asked the jury and this court to interpret the circumstantial evidence. Because what we've said, Your Honors, we've said, look, what this evidence shows is it shows that the defendant had an obsession with Nicole Simpson, and that it was an obsession that led to her murder. I guess what we could term a fatal obsession. Isn't that precisely what the statement to Mr. Shipp is saying? I have been dreaming about killing my wife. Isn't that powerful, powerful evidence of that fatal obsession, except that instead of coming in the form of circumstantial evidence, it's coming in the form of direct evidence. The defense, on the other hand, has a different interpretation of the domestic violence evidence. They say, no, it's not really evidence that shows the defendant's state of mind in terms of a fatal obsession. What it really shows is a cycle of benevolence. And they're entitled to make that argument, Your Honor. We're not saying that that is improper. That is a proper jury argument. But when they are allowed to stand before the jury and say that all the circumstantial evidence that the prosecution has introduced simply shows a cycle of benevolence, and we have direct evidence which conclusively shows that that isn't true,
Well,
that he really...
Let's sort of leap ahead to what really concerns me, because
Okay.
I agree with you that it's an interesting statement. Were I in your shoes, I would probably want to get it before the jury. What concerns me about this is two things. One, the 351.5 prohibition of any mention of polygraph or lie detector, which is included in the context of this statement. And secondly, whether or not it's fair or somehow fundamentally misleading to the trier of fact to pluck this sentence out of the context in which it was said, which is beginning and ending with comments about polygraph. So is it fair to pluck this out? That's the concern that I have.
Okay.
Mr. Goldberg.
Thank you.
I mean, that's the issue that I see. Assuming you get over the relevance question, assuming I agree with you that it has some probative value and would be of interest to the prosecution case, and that it clearly is virtually contemporaneous to the acts in question. What concerns me is the context.
Okay. Yeah, I suspected that, Your Honor. That is where the court's focus was
So
going to be.
why don't we jump to that?
Okay. But let me just point out the only reason that I was talking about relevancy and probative value is that there's a spillover effect on this question that the court's concerned of can you sever part of the statement out and then leave the portion about the defendant dreaming about killing his wife, and is that fair?
Well, Mr. Goldberg, let me ask you this, because yesterday in the discussions that I had, nobody gave me a precise offer as to exactly what statements were going to be offered.
Okay, let me read the entirety of the statement, including the portions that I believe the court finds to be objectionable, as well as those the prosecution wants to introduce. Excuse me?
Go ahead.
Thank you. I was interviewed by detectives and they asked me to take a lie detector test. And I replied, well, what did you say? This is Mr. Shipp talking. And he kind of chuckled and he says, hey, to be truthful, Ron, man, I've had a lot of dreams about killing her. And he says, I really don't know about taking that thing. He did not say he wouldn't take it. He says, I really don't know about taking it. So that is the full context of Mr. Shipp's statement to us. The portion that we want to introduce is merely the portion that says, hey, to be truthful, Ron, man, I've had a lot of dreams about killing her, unquote. That's the portion that we're interested in. But to get back to the issue that the court addressed, the reason that I made some comments about relevancy is that in our state, under our Constitution, Article 1, Section 28, we do have a right to truth and evidence in the state. And there are only certain specified exceptions to that right. And those exceptions are that a statement can be excluded. The statement can be excluded, or evidence can be excluded if it's privileged, which this isn't, if it's hearsay, which this isn't, if it's 352, which this isn't, if it's protected by the rape shield law that's codified in 1103 and 782, which this isn't, or if it's taken in violation of the federal Constitution, which it isn't. And that's what the Constitution says of our state. It shall be admitted. This is highly relevant evidence, and it doesn't come under any of the exceptions, and therefore should be admitted. Let me just point out that as to the statement, that the context of the statement was relating to the police interrogation, just to put the quoted portion in context, Your Honor. He was talking about his conversations with the police in the context of making the statement that I previously quoted. Therefore, the issue becomes, Your Honor, are we somehow going to, contrary to the clear policy of the right to truth and evidence provision, exclude highly probative evidence, evidence which really seems to blow a hole in the defense theory of a cycle of benevolence, simply because contained within that statement, there are other materials that Your Honor is rightfully concerned about, which are inadmissible. And clearly the law of the state does not lead us to what in our view would be an absurd conclusion. I'd like to get into that legal issue now, which is, I think, what is at the forefront of the court's concern. And starting with Evidence Code Section 356, which I believe is a section that's relied on by counsel, which, like Evidence Code Section 352, I think has been oversimplified again and again by attorneys and misstated by attorneys in terms of what it really stands for. And the court may recall that when we addressed 352 last, I pointed out that oftentimes attorneys talk about something being more prejudicial than probative. And they cut out that word substantially more prejudicial than probative. Over and over again in our courts, we see attorneys saying, well, Your Honor, if they put in part of the statement, I get to put in the whole statement. I think Your Honor's probably heard that. And that is not the law of the state of California. It never has been, yet it's continuously repeated as if it were handed down by Moses from the Mount. It is not what Evidence Code Section 356 says. It's not what the cases say that interpret that statute. What the statute stands for is the very common sense proposition that when you put in part of a statement and the other side can demonstrate that it is necessary to put in another part of that statement, to put it in context, that can be allowed. And there are a number of cases that interpret 356 in that way, one of which we cited in our brief, the other two which I provided this morning. One being People versus Bowe, that was at 1 Cal 4th, 281. And what it says of Evidence Code Section 356 is, quote, the section permits introduction only of statements on the same subject or which are necessary for the understanding of the statement already introduced. The other conversation referred to in the Evidence Code Section 356 must have some bearing upon or connection with the admissions or declaration in evidence. So in other words, when we need it to put something in context, then we can use Evidence Code Section 356 to do that. I think the case of People versus Pride is more instructive for Your Honor. And there what happened at 3 Cal 4th, 195, is the defendant gave a very lengthy tape-recorded interview to the police that occurred over a course of approximately 2 hours. And instead of introducing the tape recording, what the prosecution did is they called the detective that took the statement to the stand, and they asked him about only one tiny little snippet of that conversation. That was a statement to the effect that the defendant accounted for his whereabouts, and those whereabouts were false. So the prosecution simply wanted to prove that in a couple sentences of that lengthy interview, he had made a false statement. And the defense says, well, we want to put in the whole thing. We want to put in the whole thing to show that maybe the defendant's state of mind was such that he was confused or wasn't really focusing in on what the detective was asking him. We want to put it in maybe to show that he was giving an estimation or an approximation in accounting for his whereabouts as opposed to a definitive type statement. Trial court there did not allow it in. And what the California Supreme Court held was that it was properly excluded because they reviewed the tape themselves and they found that it would have been an abuse of discretion to admit the rest of the tape because it did not support the defendant's theory that there was psychological coercion. It did not help to explain or account for the statement. And in fact, the tape amply supported the prosecution's theory that the defendant gave a positive accounting for his time, which turned out to be false. So they held that if the court had admitted it, it would have been an error. So I think that very, very strongly supports what the prosecution is asking Your Honor to do here. Now let's take a look back at the defendant's statement to Mr. Shipp. The quote being, "Hey, to be truthful, Ron, man, I've had a lot of dreams about killing her." In and of itself, the statement is perfectly understandable. It is perfectly clear. It's the defendant saying, I've dreamed about killing this woman. It's very simple, very straightforward. What is the statement that immediately preceded that? I was interviewed by the detectives and they asked me to take a lie detector test. And then he chuckles. How does that possibly put any different spin on the statement? It doesn't explain the statement, qualify the statement, retract the statement. It doesn't do anything to make the statement more understandable. How does the fact that he says, I was offered to take a lie detector test, either contribute or detract from the statement that he was dreaming about killing his wife? Does it make it more likely that he was dreaming about killing his wife or less likely? I'd submit to you that it is logically entirely irrelevant. And that this is evidence, this is a statement which stands alone, which is perfectly comprehensible, perfectly understandable in and of itself. And that if you subtract the parts about the polygraph test, you don't lose anything at all. And I think the defense will have difficulty articulating why you did lose something. But even if they can, then I'd ask the court to refer back to People versus Pride, where the defense threw out some theories there as well as to why they needed the entire tape. And the court reviewed it, made its own determination, and said, no, I don't buy that. That doesn't explain, qualify, or in any way detract from the statement. And it was upheld by the California Supreme Court.
Right. How does but we have sort of the inverse situation here where they don't want the context because of the discussion of polygraph and the negative implication that can be drawn from that by the trier of fact, not fully aware of the nature and circumstances of the admissibility of polygraph evidence.
Well, then it sounds like if that's the case, we're all in agreement. I mean, then I really don't understand what the argument is about. Because if we're saying all we want is the statement and they're saying all we want is the statement, where's the disagreement?
I'll hear what their position is in a second. I'm just
All right.
asking you since it's the inverse situation,
Yeah.
really.
Yeah, I think that what they're trying to do is essentially saying, well, we don't want the statement either, but if we can, we're going to say that we want the statement, kind of, because maybe if we do that, the court will throw the whole thing out, the baby with the bathwater. And the analogy that I come up with there, Your Honor, is it's very analogous to the situation that Your Honor has undoubtedly confronted in the context of Aranda issues, where the prosecution wants to introduce the statement of the defendant, which implicates the co-defendant. And we say, well, Your Honor, just redact out the stuff that refers to the co-defendant so we can have a joint trial of these two defendants. That attempt is always going to be foiled, or they're always going to attempt to foil it by saying, well, Your Honor, we have to put in the co-defendant statement in order to place into, we have to put in the statement that refers to the co-defendant in order to place into proper context our client's statement. And in reality, what I think is happening is an effort to put in something that really doesn't logically help them for the purposes of getting a severance. Yet the courts have over and over again, and perhaps Your Honor has been in the situation, redacted those statements under Aranda and said, no, you can't put in your client's statements which implicate the co-defendant because they aren't logically necessary here. The other analogy I give the court in terms of practical situations where this comes up is in the context of a defendant's confession where he, in a lengthy tape-recorded statement where many, many topics are discussed, discusses things that are clearly inadmissible. For example, sometimes defendants will talk about their prior criminal history, what they were doing in state prison, things that clearly don't come in, and those are redacted out all the time. And I don't think the defense can be heard to say, well, those are prejudicial to us, so we don't want them to be heard by the jury. Therefore, you have to throw out the whole statement. I mean, I understand that the defense here is in a tactical bind. I mean, they don't want the statement about polygraph to come in, but apparently they also want to argue that it should come in order to get the whole statement removed. And I just don't think that that's a consistent position. They are going to be able to address us, and maybe we'll hear and they'll clarify what their position is. Maybe they'll clarify that indeed we all are all in agreement here. That statement doesn't come in pertaining to polygraphs, but the portion about wanting to kill the wife stands alone. It's highly relevant, and it should be admitted.
All right. Thank you, Mr. Goldberg. Mr. Douglas, you've been given photocopies of People versus Pride and Breaux, B-R-E-A-U-X.
Thank you, Your Honor. And I have had a chance to read the cited portions of the cases that Mr. Goldberg referred to, and I appreciate the court's convenience in that matter. Let me begin by saying categorically that we deny that the conversation ever took place or that the statements were ever made. That the court must understand as a predicate so that the court can appreciate the seriousness with which I will then have to cross-examine the witness about the entire conversation. I'm not sure how many people charged with murder Mr. Goldberg has ever represented, so I don't know how he is able to get into the defense attorney's mind and to understand what it is that the defense attorney has to do. But, Your Honor, let me tell you there is a statement that is made in connection with a conversation about polygraphs. And most importantly, right before the question comment is made, there is then a chuckle. He kind of chuckles then. Your Honor, as the court understands as a former defense attorney, I am going to examine this witness about everything given the context of that conversation, because, as I said as a predicate, the conversation did not occur. And I am going to try to demonstrate that he's lying when he says that Mr. Simpson told him that there was a dream about killing his wife. But, Your Honor, we have a problem that Mr. Goldberg's memo, a problem that the Pride case, a problem that the other case does not address, and that is Penal Code Section 351.1, which is a code section standing alone, which says, notwithstanding any other provision of law, the results of a polygraph examination, the opinion of a polygraph examiner, or any reference to an offer to take, a failure to take, or the taking of a polygraph examination shall not be admitted into evidence in any criminal proceeding. I am then in a quandary. Under no circumstances is the law enabling anyone, and I'm not going to waive that code section's applicability to this case, but in no sense does the law allow any discussion, reference concerning polygraphs to be admitted. Yet, in the statement where I must attempt to challenge the authenticity and the accuracy, there is a chuckle. Query, what does that chuckle mean? Does that chuckle mean that Mr. Simpson is taking a flip sense of the whole concept of a polygraph? Does that chuckle presage the joke that was made by the question language, such that the jury can understand that the question language was given in terms of a joke because the speaker has a general flippant, joking sense of polygraphs in general? I am unable to challenge that. I am unable to put this statement, which I say never occurred, in any kind of a context. And that is unfair. That denies me due process rights. That denies me confrontation clause rights. That violates Mr. Simpson's Sixth Amendment rights under both the California and the federal Constitution. And that is not just a technicality, Your Honor. That goes to the very essence of what a fair trial is all about. I cannot challenge a statement that I say never occurred, a statement where there is, even from the mouths of the witness, information that might suggest that the statement was not offered in total seriousness and true appreciation for the value of that statement. And there's another problem which runs into 352. I am informed, although I have not spoken to anyone professionally, that whenever there are statements of dreams or questions of dreams, it is not necessarily indicative of the state of mind of the speaker. It does not necessarily mean that if he dreamt something, it is relevant to an issue in the case that he killed her, and that there is a misconception that Mr. Goldberg apparently holds as well, that there is some probative nexus between someone saying that I dreamt about something, assuming for the sake of my statement that the statement was made, and that it means something that is relevant to the trier of fact. Therefore, there is going to be a great deal of scientific testimony that I will have to try to obtain to put on people that will be able to talk about dreams, and particularly in the context when this man is told that very day that a woman with whom he had been involved for 17 years had just died, and he is going through and he wasn't around, and he is told on the telephone that this happens, and he rushes back, and he is consumed with all of this grief and all of this uncertainty and all of this emotion, and he is tired because he didn't sleep going to Chicago and didn't sleep coming back, and there are these family members that are also grieving with him. There is an entire context, Your Honor, that it would be unfair to require that we simply examine under a microscope 6 or 7 different words without appreciating the entire context in which it's offered. I argue, Your Honor, that on this level, the answer is clear. when you must balance the obligations of the people and their interest in getting in this evidence against the possible danger of unfair prejudice, against the potential for consuming undue time, against the inability for me to vigorously contest the very context in which the statement is weighed, the results are clear, and you should rule in favor of not allowing the statement to come in.
Thank you, Mr. Douglas.
May I respond?
I'm interested, Mr. Goldberg, in Mr. Douglas's argument that what is the significance of dreams?
Well, yeah, I
intent.
was very interested by that argument too, because it seems to be so preposterous. I mean, let's imagine, for example, Your Honor, that he simply had said, I've been dreaming about Nicole every day of my life, or I've been dreaming about Nicole constantly. Not that he was going to kill her, just that he'd been dreaming about Nicole. Wouldn't that in and of itself be relevant to show this issue of this obsession, this fixation on this woman, that he has not let go of it, let go of her? The fact that he's dreaming about killing her simply magnifies several hundredfold the relevance of the statement that he's been dreaming about Nicole. It's highly relevant and highly material here.
Are you going to offer some psychiatric or psychological testimony to back this up, that there's some probative value to this?
If it's admissible, we will. If the court, we've litigated extensively this issue of can we put in expert testimony, and I wasn't absolutely clear what the bottom line ruling of the court was on that issue. But obviously the court knows we would like to put on expert testimony. But I think that whether you have expert testimony or not, this is the kind of issue that people understand from their own experience. And we all have dreams, and every person on that jury does, and they understand from their own experience the significance of this kind of evidence. And I think even Your Honor, as a case of first impression, when I started addressing you this morning, cut me off, said, well, Mr. Goldberg, I can kind of, I'm paraphrasing now, I sort of appreciate the relevance here. I'm more concerned about this polygraph issue, because I think that as a matter of common sense, that a person looking at this, even on a case of first impression, is going to understand how highly probative it is. I'd also like to address some of the other comments that were made just a few moments ago. First of all, as to the chuckle. I don't understand the defense argument here. I thought we were going to get clarification, and now I'm even less clear. Do they want the statement about the polygraph in, or do they not want it in?
They don't want any of it in.
They don't want any of it in. We know that. But if they're going to get the statement about the dreams in, then I'm not clear. Do they feel they need to then bring in the polygraph for purposes of explaining it, or do they still not want to? I don't think that position has at all been clarified for us. And I think the reason that they're having difficulty clarifying it is because it seems like there's an inconsistency. I mean, on the one hand, they want to argue that it's inadmissible, and on the other hand, they want to turn it around and argue that it needs to be admitted for the purposes of clarifying the statement. And I think that should be interpreted as what it is. It's they're staking out a position that is designed to maximize the likelihood of, as I said, throwing out the baby with the bathwater, rather than specifically telling you what it is that they want and what it is they don't want. But the chuckle itself, we have no objection to. Now, counsel says, well, I want to show that the chuckle relates to the polygraph test. In other words, I want to put the chuckle in context. Why? How does that help their position, that the defendant may have had a flippant attitude about polygraphs? What on earth does that begin to say about the context of the statement that we're concerned with about dreaming about the murder of his wife? That's the statement we're interested in putting into context. What Mr. Douglas should have argued is he should have argued that somehow the chuckle reflects upon that statement. But to the extent that it does, the chuckle can come in. Again, this is why I think that the case of People versus Pride is particularly significant, because, we don't expect the defense to roll over and say, look, we really don't have a good theory on this. They're going to come up with an argument as to why it is that simply taking that one statement is going to be out of context, and why it is, I suspect that they need to put it back in context, just as the attorneys did in Pride.
Let me redirect your thought, and I apologize to you for this, because
That's
I had...
okay.
Part of the problem was in our discussions yesterday, what I had been, what my understanding of the statement in particular was that I have been dreaming about killing her. And the statement is a little more oblique. It said I have had a lot of dreams about killing her, which is maybe just semantics, but it's a little more indirect as a thought process. So the question then becomes, what is the probative value of putting your head on the pillow and having dreams about killing your wife?
In a case where the defendant is charged with killing his wife, it seems to be highly, highly probative that he's been having a lot of dreams,
Sure,
not just one.
On the surface, it is. I agree with you that the first immediate reaction is clearly that's relevant. Clearly, the jury ought to hear about it. I'm just saying, when you get down to the substance of it, though, what does it really mean?
You get down to the substance of the...
What does it really mean that you've had dreams about killing your wife?
Yeah, and that's why I started the discussion with talking about our domestic violence evidence and showing that is circumstantial evidence of what you could call a fatal obsession with this woman. And here, it's almost as if he's saying, I have a fatal obsession with Nicole, except people don't talk like that. And the way that he expresses it is he says, I've been having a lot of dreams about killing her. And to me, that seems like it's so obviously powerful, compelling evidence of this fatal obsession with this woman that it's almost difficult for me to think to articulate, to put it into words. It's one of those things that almost seems to leap out.
Self-authenticating.
Yeah, I suppose you could say that, Your Honor.
Something like that. All right. Mr. Goldberg, how would you propose to present this, knowing the minefields that are apparent on either side of the sentence?
This is an issue that comes up over and over again, and we have a lot of experience dealing with it because we redact and change statements in courts of law all the time. And the way that this is handled is you speak to the witness.
I understand that.
Yeah.
I'm just saying, have you prepared to do that?
Well, I'm not going to be presenting this witness, but I'm sure that whoever does will sit down with him and explain the court's ruling. And
I thought this was the next witness up.
Yes, but the court hasn't ruled on it. I don't know whether Mr. Darden has actually gone through and said, we're going to have a hearing on this issue. It would be rather difficult to explain to a witness. You may have to keep something out of your testimony, but we're not sure at this point. And it doesn't really take too long to give that kind of an explanation. So the proposal is you speak to the witness, you tell him exactly what you're going to be asking him, what specific question you're going to be asking about a conversation that took place on a certain date at a certain location. And did Mr. Simpson say something about dreams? Yes. Well, what did he say? And then the witness will give that one single sentence. So I don't see that mechanically that there's a lot of difficulty in terms of presenting that evidence, Your Honor.
I don't suppose either side has found cases that deal with admissibility of dreams.
No, I can't say that, quite frankly, we didn't even research that, Your Honor, because it seemed like our thought process was much the same as the court's, and that we were more concerned about the issue of the polygraph and redacting that out. I mean, the issue of relevance always turns upon a juror using their collective life experience and their common sense for the purposes of interpreting evidence. The counsel made this exact same argument about the domestic violence evidence, Your Honor. Well, just because you hit someone, it doesn't necessarily mean that you're later going to kill them. Just because you do these various things doesn't necessarily lead up to murder. But what we're always asking the jury to do with any kind of circumstantial evidence is use common sense, life experience, and that's all we're going to be asking them to do here.
All right, I'm going to give Mr. Douglas another comment simply because of the unusual nature of this.
Your Honor, thank you very much for this opportunity. There is clearly a minefield that we will be delicately walking around in between if we get into this particular area. And as well, Your Honor, we are going to be opening the door because in this instance, it's important to remember that on June 15th, 1994, Robert Shapiro sent a letter to Tom Van Adder asking and offering and accepting the request for a polygraph so long as the results were stipulated and admissible by stipulation. And therefore, Your Honor, I cannot simply rest on 7 certain words. I've had a lot of dreams about killing Nicole, and then move on to my next topic. Because before those words were uttered, there was a chuckle. And Ship will say there was a chuckle. And that chuckle does have significance because it might even arguably place into some question the seriousness of the statements that followed. Is he chuckling because the whole idea of a polygraph was funny because he's innocent and of course he passed? Is he chuckling because it's a silly idea because he's innocent and he throws in just by happenstance the sentence, well, you know, I've had dreams about killing her? Is he chuckling because the whole idea of having dreams is funny to him as well? Who knows? But to allow simply to have the words come up without allowing the context that traipses around a very delicate minefield of error and clear error, because we're talking about a code section that is mandatory and that is clear, because polygraph testimony is not admissible, because polygraphs in and of themselves have not developed the certain reliability such that they can be admissible. It's not even susceptible to a Kelly Fry hearing, Your Honor. The legislator has spoken as a matter of law, and it is binding. And because to do so would open up the doors about this letter where Mr. Simpson's lawyer 2 days later offered to take a polygraph so long as it was admissible. And in fairness, we'd want to bring that out to put it into the context that he really didn't have any dreams about killing her, and he really wasn't reluctant to take an examination. I think it's best and the proper course would be to let it all out, to keep it all out.
All right. Thank you, counsel. Well, no, it's just an unusual issue, and I just wanted to hear one more comment from the defense. I just wanted to solidify something in my mind. All right, the objection to the comments will be sustained as to any commentary regarding polygraph under Evidence Code 351.5, if I'm not mistaken. Point 1. The statement regarding the dreams about killing will be admitted. Mr. Darden, are you going to be presenting this?
Yes, I am, Your Honor.
Is your witness prepared and instructed?
I'm going to need 10 minutes, Your Honor. He's in the building. He's upstairs. I just want to make sure he understands a couple of things.
All right, any other minefields that I need to deal with before we invite the jurors? All right, as a matter of scheduling, I indicated to counsel yesterday that we would recess today at 2 o'clock because some of the court staff and some of the counsel have asked permission to attend a funeral this afternoon. I've indicated that I would allow them to do so, so we'll recess at 2 o'clock. We also have a 4 o'clock hearing as to Marguerite Simpson this afternoon, which I asked Mrs. Robertson to contact Mr. Jones to see if he had another date. All right, we'll try to reschedule that with Mr. Jones. All right, Mr. Douglas.
Since there is, as a predicate matter, as a threshold matter, a challenge that the statement was even made, that the preliminary fact of the statement, separate from whatever inferences might be offered to flow, I would ask under 403 that there be a hearing as to that statement at an appropriate time. I don't want to take from the jury right now, but I would ask, Your Honor, that as a preliminary matter that be allowed, and secondarily, I would ask for my own purposes and my office's purposes that I be allowed to know that I can seek to obtain expert witness testimony about dreams, because I am going to intend to challenge any sort of probative weight that the people are going to attach to this alleged statement, which I contend never occurred.
Mr. Darden, you want to address that issue? 403 issue.
Not the psychic hotline issue, but the 403 issue, Your Honor.
Yes.
Your Honor, Mr. Douglas has a copy of our taped interview with Mr. Shipp. If the court would like a copy of that taped interview, I'm happy to provide a copy. I think it's inappropriate to interrupt Mr. Shipp's testimony at this point. Mr. Douglas knows what the witness has to say. He knows what he has said in the past. The witness is adamant that the statement was made. It's a question for the jury, an issue for the jury to resolve. There's no 403 issue here at all.
All right. Mr. Douglas?
Because, Your Honor, this evidence is potentially prejudicial and risky, I believe, and because the court has one representation at sidebar about what is going to be said and another representation here in open court, there's another representation in a book where this witness's conversation has been reflected. There are aspects of this witness's background that I think will be probative for the court to evaluate preliminarily. I think the more prudent course would be for this court to first hear the entire statement so this court can understand why I think it important that I go into the circumstances and the tenor under which it's spoken before the court allows the jury to hear this certain statement. I'm not going to ask for a 403 with every particular witness. I do intend to ask for 403s with the domestic violence witnesses whom we dispute that the act occurred, that Mr. Simpson was involved in the act, or that there is the 1101B inference that is properly drawn given the factual context. On those instances, I will be asking for 403s. On this instance, because the court needs to preview the evidence, the court needs to understand why I say I cannot do justice to my client on trial for murder with the fifth witness in this case without my being able to vigorously cross-examine him on that particular point.
Mr. Darden, do you agree the court has discretion to conduct these 402, 403 issues before the jury and can strike testimony if the foundation is not there?
Yes, Your Honor, but this ploy pursued by counsel was one we've seen before, Your Honor. We saw it in the Chinatown murders. What counsel is really asking for is a dress rehearsal of a witness whose testimony is extremely damaging to his client. The court has a copy of a transcript of the taped interview. The witness is here. He is ready and willing to testify in a manner I believe will be consistent with that transcript. There's no 402 or 403 issue here. The court will just be wasting its time and giving Mr. Douglas, an extra shot at cross-examining our witness. That's unnecessary under these circumstances. It isn't fair. Mr. Douglas has known about this witness and his testimony for 10 days. And if he, let's get this on. Let's finish this trial. Let's stop dilly-dallying around.
Apparently it's in the book now as well. All right, the court will undertake the 403 examination during the course of the actual testimony. All right, we'll stand in recess for 15.
May I interject this? If we're going to have a 403, I would like not to have my witness's testimony interrupted moments before he provides this important information or testimony. If there is a concern, if the court has a concern and the court wants to do a 403 hearing, let's do it right now. Don't interrupt his testimony right before he...
Well, Mr. Darden, what do you want? Do you want the 403 hearing now, or do you want it during the course of the testimony?
I don't want it ever.
Take your pick.
With these things, Judge. I miss it sometimes. Thank you.
You're welcome. 15.
come to the 18th floor that stop here on the 9th. It takes several minutes to get one. It's a nightmare. Every day. It's killing me, Judge.
It's stairs, James. That's gonna
Thank you, Mr. Chair.
You're welcome.
We are making a habit of this.
It's not, it really isn't our fault. Sometimes we wait 10, 12, 13 minutes for an elevator.
Plus, we have to deal with public defenders that key it past us. You know, what's going up is not coming down.
We'll have to talk about that.
Okay.
All right, counsel, I want to take up a couple of matters before we actually invite the jury to join us. Mr. Shapiro, over the break, over the 15-minute break, advised me of a problem, something that is being reported. Mr. Shapiro, do you want to enlighten the prosecutors about this? Counsel, why don't you have your witness have a seat, because it'll be a bit before we get there. I don't think we need to reproach.
You have to address it now.
No, I'm just want to put on the record what the state of the situation is.
I have informed them of our conversation, Your Honor.
All right. Well, Mr. Shapiro, this is something I need to put on the record at this point. You've indicated to the court that apparently the chief of police has made some indication that he's received a communication from this court.
No, it was reported to me that there were some news reports, not directly from the chief of police, but from some other members in the media, that there were communications between yourself and the chief of police regarding whether or not the chief of police should make any statements regarding this case. I thought it incumbent upon myself as an officer of the court to inform Your Honor in case you had not heard those. Your Honor has assured me, which is exactly what I anticipated was the case, that you have not talked with the chief of police. But I wanted to make sure that if these rumors are out in the press and they're reported to me, if they're reported to others, that it's something Your Honor would and should want to know about.
I think perhaps this is a misinterpretation. If you recall, about 3 months ago, when we were dealing with the leaks problem, at the request of both parties and with the consent of both parties, I sent a letter to Chief Williams asking him to do whatever he could to investigate the leaks and stop anything that was leaking out from his department.
That was at our request.
That was the only communication this court has had with the chief of police.
I think the record is clear, and that was exactly what we anticipated. And I think it's very important that the press accurately report.
All right, thank you for bringing that to my attention, Mr. Shapiro. There's one other matter. I noted that Tracy Savage, good morning, Ms. Savage, is a guest in our court today as a media representative, and I recall that she is on the defense witness list, and there is a witness exclusion order at this time, and I wondered what the party's position was about Ms. Savage remaining.
We approach them all, yes.
Sure.
She here to
Ms. Savage, would you stand and wave to Mr. Cochran? All right, Mr. Cochran.
Yes, sir. Good morning, Your Honor. Your Honor, in the matter involving Ms. Savage, who's with us today in a reporting capacity, we discussed with Mr. Simpson, and we understand that she has a job to do. And I believe that on the issue with regard to the socks, where we think her testimony would be relevant, I would suggest to Channel 4 that she not be in here covering those days, because we'd have to ask her to be excused. For today, we have no problem. I believe with regard to much of the foundational material, Ms. Clark and I will be able to stipulate, because it was a date in which she and I mutually called for an internal affairs investigation, because there was these leaks and results when the socks were still there. So our position is that she can stay here now. We will waive the court's order so she can stay here today, and ask only that Channel 4 be fair in their reporting.
All right. And I take, Ms. Clark, you have no objection to that as well?
That's correct, Your Honor. The people have no objection. To a large extent, I think that the matters that counsel is going to be seeking to put before the jury are a matter of public record, if not actually a matter of videotape that has already been broadcast, and I don't see any problem with Ms. Savage remaining.
All right. Then objections having been waived, will allow Ms. Savage to remain for those portions of the proceedings that have nothing to do with the DNA testing. However, Ms. Savage, you should have your station manager reassign you when we get to the DNA issues. All right. Also, you're not to watch any television coverage of the DNA issues. All right. Let's have the jurors, please.
Judge, did we reschedule the motion to quash on Marguerite Thomas?
We have not yet been able to make contact with Mr. Jones.
Yeah, so we're clear. Your last statement about not watching any television coverage regarding the DNA hearing, that was not a joke.
No.
That was not a joke. Some people laugh, but that's not a joke.
No, I think Ms. Savage understands the court's order, correct? All right, she indicates in the affirmative. Thank you for having kept you in the small room so long this morning. I thought we would get started within 10 or 15 minutes of our 9 o'clock start time, and unfortunately, other things came up that I had to deal with. In your defense, Deputy Magnera urged me not to bring you down until 10 o'clock, but I thought we'd get it done sooner, but these things happen. All right, are the people ready to call their next witness?
Yes, Your Honor, we are.
All right, Mr. Darden.
People call Ron Ship to the stand, Your Honor.
Sorry, Mr. Ship.
Raise your right hand, please. You can solemnly swear that the testimony you may give in your class now opinion before this court should be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Please be seated and state your first and last names for the record.
Ronald Ship, RONALD SHIPP.
Mr. Darden.
Good morning, sir.
Good morning.
Mr. Ship, are you acquainted with the defendant in this case?
Yes, I am.
How long have you known him?
Approximately 26 years.
And do you recall the circumstances in which you first met him?
Yes, I do.
What were those circumstances?
When I was about 16 years old, my brother, Mike, played against OJ in high school up in San Francisco. And he had come down to Los Angeles right after OJ had won the Heisman Trophy. And myself, Mike, and my brother Skip went over to OJ's house and congratulated him. That was when I was 16 years old.
And did you and the defendant develop a friendship after that initial meeting?
We weren't very close at that time. I'd run into him from time to time, and every time I'd see him, he'd ask me how was Mike doing, and but we weren't really that close at that time.
Okay. Well, as the years went on, did you develop a closer relationship? with
I'd
the
say
defendant?
approximately from about 1978 on.
Did you visit the defendant's home?
Yes, I did.
On how many occasions?
How many occasions?
Yes.
Gee. See, in 78, I was a police officer at the time, and I was assigned to West Los Angeles Division. And at that time, I would go up there on occasion, probably approximately maybe 2 times a week, up until 1982.
You were an LAPD officer?
Yes, I was.
When did you join the LAPD?
1974.
And you're no longer an LAPD officer?
No, I'm not.
And when did you leave the LAPD?
I believe it was October of 1989.
And you say that during the time that you were a police officer, you were assigned to West LA Station?
And I was assigned to West LA from 1978 to 82.
And West LA Station has jurisdiction over Brentwood, is that right?
Yes, it does.
Now, a moment ago, you testified that there was a time period in which you would go to the defendant's house perhaps 2 times a week.
Approximately.
On those occasions, were you on duty?
I'd say half. Sometimes I'd come by in the patrol car, and other times I'd go by there and play some tennis.
You played tennis at the defendant's home?
Yes, I did.
On his tennis court?
Yes, I did.
On those occasions when you played tennis at the defendant's home, was he at the home?
Sometimes he'd be there and sometimes he wouldn't.
Did you have to get permission to play tennis on his tennis court?
No, I did not.
You could just show up and play tennis.
Yeah, OJ trusted me. So I didn't really have to call. I'd call and talk to.
Whole world.
You didn't have to get permission to play tennis there.
No, all I had to do was clear with. I'd call the maid or whoever was there and just let them know I was coming.
You said that OJ or the defendant trusted you?
Oh, yes, he did. I felt he did.
Now, what period of time are we talking about here?
From playing tennis?
Yes.
Approximately from 1978 to 82.
Was there a security gate at the house on Rockingham
Yes,
at that
there
time?
was.
Did it require a security code or something to open the gate?
No, to my knowledge, there was just a button that you would push.
How about after 1982? Did you continue your relationship or your friendship with the defendant?
Yes, I did. I didn't go by there as frequent. Once I transferred downtown, and maybe I went over there maybe once every maybe 2-3 weeks.
Did you continue to play tennis?
Yes, I did.
On those occasions when you went to the defendant's home, while you were on duty, did you ever take other officers to the defendant's home as well?
Yes, I did.
Did other officers also play tennis?
There was only one officer I used to play with. Yeah, that I recall, was one officer.
And what is that officer's name?
Chuck Smith.
And if you know, is he still a member of the LAPD?
Yeah, he's still at West LA.
Did other officers also visit the defendant at his home?
To my knowledge, no, unless they came over with me.
Or did you take officers to the defendant's home other than Chuck Smith?
Yes, I did. If I was on patrol, sometimes I would take people over there. I used to get a kick out of not telling them where I was going and ringing the doorbell and have OJ come out and greet them.
How many other officers would you say you took to Rockingham?
Wow. I'd have to say approximately maybe 40 guys, maybe.
And were these 40 guys all members of the LAPD's West LA division or station?
Most of them. Most of them were.
Was there ever any animosity or hostility between those 40 guys that you just described and the defendant?
No way. No.
Did any officer get the defendant's autograph?
Yeah, a few of them. I got autographs from OJ for a few of them. A couple were women that I got autographs for them and their kids, female partners.
West LA division holds an annual Christmas party, is that right?
That's correct.
Was there ever an occasion where you were in charge of getting celebrities to come to the annual Christmas party?
One particular time, yes.
Do you recall which year that was?
I believe it was either 1980 or 81.
And did you arrange for a celebrity's appearance at the Christmas party?
I thought I did.
Who was that person?
OJ.
The defendant agreed to appear at the LAPD's annual Christmas party?
Yes, he did.
Did you ever meet Nicole Brown?
Yes, I did.
Do you recall when that was?
It was either 79 or 80. I'm not sure.
Were they married at the time?
No, they weren't.
Did you ever visit Nicole Brown at Rockingham?
Yes, I did.
On how many occasions?
I can't remember exactly when she moved in. So whenever she moved in, probably about maybe once a week. We were once again on patrol most of the time.
And did you consider Nicole Brown a friend?
Yes, I did.
As you did the defendant?
Yes, I did.
And do you and the defendant remain friends today?
Well, I still love the guy, but I don't know. I mean, this is a weird situation I'm sitting here in.
You say you still love her.
Sure.
Did you ever attend parties at the defendant's house?
Yes, I did.
Did you attend his wedding?
The reception.
Did you ever have intimate and personal conversations with him?
Yes, I did.
What kinds of things did you talk about during those personal and intimate conversations?
Sustained.
You understand the term intimate and personal?
Yes, I do.
Did you ever discuss your health with the defendant?
No, I did not.
You ever discuss your relationship with your wife with the defendant?
I don't believe so.
Did he ever discuss his relationship with his wife, Nicole, with you?
Foundation, Your Honor. It's a long time ago. Irrelevant, perhaps.
I think this is foundational. Well, we're not going to content yet. Overruled. You can ask the foundational questions.
Did the defendant ever discuss his relationship with his wife, Nicole, with you?
Yes, yes, he did.
You testified a moment ago that you understand the term intimate and personal, correct?
Yes, I do.
Could you give us some examples of some of the intimate and personal conversation you had with the defendant?
Yes, Your Honor. May we approach one off the proof?
All right, with the reporter, please. All right, thank you, counsel. Perhaps, Mr. Darden, you can give us a little tighter focus on our inquiry here.
I'll withdraw the question.
All right.
In addition to playing tennis at the defendant's home, what kinds of other things did you and the officers you took to his home do?
Other than playing tennis, I never, officers I took over there, we didn't do anything else.
Did the defendant have a swimming pool?
Yes, he did.
Did you ever swim in the pool?
I did.
How about the other officers that you took over?
And when I took over, swam in the pool.
Now, do you know whether or not those other officers ever went back to the defendant's house on their own?
Not to my knowledge.
You have no firsthand knowledge of that.
I do not.
Now, were you still a member of the LAPD during the first week of January 1989?
Yes, I was.
And did you receive a telephone call from Nicole that week?
Yes, I did.
And did she ask you to do something?
Yes, she did.
What did she ask you to do? Question, Your Honor.
I'm sorry?
There's a question. What did she ask him to do?
And the content of that answer is hearsay.
Not asking for the answer to the question, just asking the question. Not all.
Sustained.
She asked you to do something,
Yes, she did.
and this was during a telephone call.
Yes, it was.
Did you call her or did she call you?
She called me.
Did she appear upset or sound upset at all?
No, I will tell you that.
Overruled.
Oh, I'm sorry. Yes, she did.
Is she hysterical?
No, she was not.
And what did you do after she asked you to do something?
She asked me,
Sustained. Mr. Ship, the question was, what did you do after the request
Oh,
was
I'm
made
sorry.
of you? Not what
when I
was
got off of work, I went over there.
Now, you're going over there. Was that in response to something she asked you to do?
Yes, it was.
And did you do exactly what she asked you to do?
Yes, I did.
Went to the defendant's home on Rockingham?
Yes, I did.
Did you take anything with you at that time?
No, I did not.
Did you drive your personal car onto the property of Rockingham?
I can't remember if I did or not. Sometimes I would park on the grounds, and sometimes I just park on the street.
Did you knock at the door?
Yes, I pushed the buzzer.
Did she come to the door?
She buzzed me in.
Okay. Did you knock at the door then?
No, I just walked on in. A lot of times when they buzz you in, your door's open, you walk in.
Okay. So you just walked on into the house.
Walked on in.
And did you see Nicole Brown at that time?
Yes, I did.
Now, what day of the week was this, if you know?
I'd have to say it was either, I think Tuesday or Wednesday.
And how many days after January 1, 1989, was it that you went to the defendant's house?
I think probably
Probably what?
2 days.
So somewhere around the 3rd or 4th?
Around, yeah, right on the 3rd or 4th.
And did you see Nicole Brown at that time?
Yes, I did.
And did you notice anything unusual about her at that time?
Yes, if I remember, she had some injuries that had started to fade.
Speculation. No foundation.
Overruled.
What injuries did you see at that time, Mr. Ship?
If I remember, I mean, I couldn't see it that well because I remember she had makeup on, but if I remember, there was some swelling about her head somewhere. I remember it was covered up pretty good.
She had makeup on,
She had makeup on.
covering her injuries,
Right.
but you could still see
I
some
could still
semblance
see,
of those injuries.
yeah, a little bit of it.
Excuse me, Mr. Dart and Mr. Ship, you all going to have to talk one at a time.
And did you have a conversation with her at that time?
Yes, I did.
What was her demeanor during that conversation?
When she first started out, she was like she always would be when we would talk. She was kind of joking. And then after a while, she just kind of got into actually what had happened and started telling me what had happened between her and OJ.
Did she show you anything at that time?
No, she did not.
What were your duties and responsibilities with the LAPD during the first week of January 1989?
At that particular time, I was on loan to West Los Angeles. Actually, it was the Valley Division Forgery Unit, which was actually out of West Los Angeles.
Now, does the LAPD have a police academy?
Yes, they do.
What exactly is a police academy?
Police Academy is where all the recruits receive your training prior to becoming a full-fledged Los Angeles police officer.
And were you ever assigned to teach any particular subject at the police academy?
Yes, I was.
Were you so assigned during January of 1989?
No, I was not.
When had you last been?
Actually, let me correct. Okay, I was assigned to the academy, but I was on loan to forgery, West LA Forgery,
Okay, so you're still a member of the police academy teaching staff.
on paper.
And did you specialize in a particular area?
Yes, I did.
You taught a particular subject.
Yes, I did.
And what was that subject?
Domestic violence.
You taught domestic violence,
Yes, I did.
and you taught that to other police officers.
Other police officers and recruits.
What kinds of things did you teach those other police officers and recruits?
Pardon me?
What kinds of things did you teach those other police officers and recruits?
Overruled.
I taught them, for the most part, the dynamics and profiles of the victim and the batterer, in relation to domestic violence.
What does that mean exactly?
Okay, for the most part, what it is, it's the makeup, how can I say this? I'm drawing a blank right now. But anyhow, for example, like the victim, it would talk about exactly what makes up a batterer. I mean, what makes up a victim as far as being like their background, low self-esteem, just different profiles.
You also talked about the profiles of the battered.
Right.
Now, may I have one moment, Your Honor?
Certainly.
Strike that. At some point, did you develop a teaching plan or teaching outline?
I didn't develop it. It was already given to me from the academy.
Your Honor, I have here in my hand that which appears to be a teaching plan. May it be marked People's 8.
All right, People's 8. How many pages is that? Appears to be multiple pages. Sure.
Showing you People's 8 for identification, Mr. Shipp. Does that appear to be a copy of teaching outline on domestic violence that you just mentioned a moment ago?
Yes, it is. It's a portion of it. It's enlarged from how I remember it, but yes, it is.
What is page 1 entitled?
Victims pro.
Sure.
What is page 1 entitled?
Victims profiles.
And page 2, what is it entitled?
Batterers profiles.
And page 3?
The cycles of battering.
Is there a 4th page?
Battering and arguing.
Page 1 lists some of the characteristics common to women who remain in abusive relationships.
Yes, it does.
Could you list those characteristics for us?
Yes, it has here self-blame and guilt. And the next one is lives in constant fear. High level of dependence. And underneath it says economic and or emotional. And it says commitment to relationship. Will do almost anything to keep the family together. Traditional sex role, meaning she's a mother.
This witness. It's not that and I think that there is a hearing that we want to have about this entire situation.
Counsel has an objection. We should ask her to approach the side.
All right, that's a speaking objection. Let me see counsel at the sidebar, please. All right, thank you, counsel. Ladies and gentlemen, let me just remind you that the testimony that you were hearing regarding the 1989 incident is limited. This testimony is limited to that particular incident at this time. All right. Mr. Darden.
Can I have the last question read back, Your Honor? And the wallet.
I think you asked Mr. Shipp to tell us about the characteristics on the list.
You just read the characteristics of a battered victim.
I got halfway.
Okay. Shall we start at the top, begin from the beginning, or shall we start midway? You know?
Well, reading the document is really not what's at issue, isn't it?
Pardon me?
Isn't it at issue his discussions with the various parties?
Sure. Absolutely. Continue reading, please.
We are. I object to reading the document, Your Honor.
Him reading the document is irrelevant to the conversations with the parties at this time, isn't it?
Thank you, Your Honor. Okay, but you had this conversation with Nicole Brown at the house a couple of days after January 1, correct?
Yes, I did.
Now, did you have that teaching plan with you at that time?
The first time I went over there?
Yes.
No, I did not.
Was the defendant present that first time you went over?
No, he was not.
How long were you at the house that day, that first time?
First time I was there probably think maybe 5 hours, somewhere around there.
And did you return to the house again?
The next day, yes, I did.
And did you bring anything with you at that time?
Yes, I did.
What did you bring with you?
I made copies of portions of the domestic violence lesson plan.
You made copies of the lesson plan in front of you?
Yes, I did.
Okay. And when you arrived at the house, was Nicole Brown there?
Yes, she was.
Was the defendant there?
No, he wasn't.
Did you have a discussion with Nicole Brown?
Yes, I did.
Did you show her the profile of the battered woman,
Yes, I did.
the victim's profile?
Yes, I did.
Did you discuss it with her?
Yes, I did.
Did you discuss with her each of the characteristics of the victim profile?
Yeah, I showed them to her and just went down, and we read them together.
Did you ask her which characteristics seemed to apply to her?
I really can't remember if she actually came out and said, "Well, yeah, this is all me," and I really can't remember that. I don't recall her actually saying, "Yeah, this fits all me." It was the batterers thing that she focused the most on.
So she focused mainly on the batterer's profile.
Right.
And did she ask you to do something with that batterer's profile?
Yes or no?
Yes.
This is inappropriate.
No, it's an objection, but the question calls for a yes or no answer.
Am I answering it?
You may.
Yes, she did.
And did you do what she asked you to do?
Yes, I did.
When was the next time that you saw the defendant?
It might have been later on that week. I'm pretty sure it was.
Do you recall where he was when you saw him?
At the house.
Were you also at the house?
Yes, I was.
And had you gone to the house for a specific reason that day?
Yes, I did.
And what was that reason?
To talk to OJ about the profiles on Nicole's request.
By the way, the second time that you visited Nicole that week, did she show you anything?
Yes, she did.
What did she show you?
She showed me some pictures.
Your Honor, I have it in my hand 3 Polaroid photographs. And they be marked people's 9, 10, and 11?
Yes.
Defense counsel. Questions while we wait for defense counsel? Thank you, counsel. May I approach, Your Honor?
You may.
Mr. Bishop, let me hand you people's 9 for identification. Do you recognize that photograph?
No, I don't.
You've never seen that photograph before?
No, I have not.
Who was the person depicted in the photograph, if you know?
Your Honor.
Overruled.
Who was the person in the
Nicole.
photograph?
Nicole Brown.
That's Nicole Brown?
Yeah, that's Nicole Brown.
That picture wasn't shown to you on, during that first week of January 1989?
No, it was not.
Showing you people's tent for identification. You recognize that photograph?
No, I do not.
Was that photograph shown to you?
No, it was not.
Showing you People's 11. Who's depicted in that photograph?
Nicole Brown Simpson.
Was that photograph shown to you?
No, it was not.
You've never seen these photographs before?
No, those weren't the ones that she showed me.
These are not the photographs that Nicole Brown Simpson showed you from the first week of January 1989?
No.
Overruled.
So the record is clear. Each of these photographs depict Nicole Brown, is that right?
That's correct.
But you were shown some photographs.
I was shown some photographs.
And were those photographs photographs of Nicole?
Yes, they were.
How many photographs did she show you?
Approximately 4, maybe 5.
Were those photographs Polaroid photographs?
I think they may, I can't remember. I think they may have been. No, she told me she took them of herself. And so I can't really remember if they were Polaroid or not.
Did those photographs depict Nicole's face?
They weren't really that close up. They were more, if I remember, they were more of her body. The ones that I saw.
What parts of her body were depicted in those photographs?
I remember her left arm stands out, and also her, if I'm not mistaken, her left upper thigh.
Any other parts of her body that you recall?
That's all I can remember.
And did you notice anything unusual on her left arm and on her upper thigh? That is, as shown in those photographs?
Overruled on that basis.
No.
Sustained.
The photos she showed me were from the
Hold on.
past.
Hold on.
Okay.
Let me see counsel at sidebar. All right, thank you, Madam Reporter. Mr. Darden?
The photographs that you saw, sir, of Nicole Brown's left arm and thigh, did you notice any injury to those areas on her body in those photographs?
Yes, I did.
What did you see?
They were like bruises, darkish, kind of bluish color.
Why did she show you those photographs?
Sustained.
Do you know why she showed you those photographs?
Probably. Sustained.
You were having a discussion, though, about the batterer's profile. Is that correct?
Correct.
Was it during that discussion that she showed you those photographs?
Yes, it was.
And during your discussion of the batterer's profile, did you and Nicole Brown agree on a specific course of action?
Yes, we did. That's when,
That's the question.
Correct. Next question.
Did you intend to pursue the matter further?
Yes, I did.
What did you tell Nicole Brown you were going to do?
That I would meet with OJ.
For what reason?
To discuss the batterer's profiles.
And did you meet with the defendant?
Yes, I did.
Did you show him the batterer's profile?
Yes, I did.
And that profile does list certain characteristics of a batterer, is that right?
That's correct.
Now, during that discussion, did you discuss with him the events of January 1, 1989?
Yes, I did.
Relate to us the content of that conversation, please.
OJ had said that they had gone out that night. He and Nicole, Marcus, and Kathy. And they had had a pretty good time. And that they had too much to drink. They were partying too much, and when they got back, they got in an argument.
Did he say what the argument was about?
Yeah, I mean, he said that they had been kind of intimate, and then that in the middle of it, they started arguing, for the most part.
What do you mean they were kind of intimate and in the middle of it they started arguing?
Well, they were, from what he told me, they were making love. And I guess Nicole had wanted to stop for whatever reasons. And they began to argue.
Did he tell you what happened next?
I believe at the time he told me that Nicole was the aggressor and came after him. And that he was acting in self-defense.
What did he say that he did to Nicole in self-defense?
He had told me what he had, at the time, that he had was defending himself and had pushed her away. And he didn't really hit her.
He said that all he did was push her away.
At the time,
Did he say what happened next?
I think he said that then, she got hysterical and called the police on him.
Did you ask the defendant if he beat her up?
No, I didn't. Not at that time, I didn't.
Continue on then with the conversation you were having with the defendant regarding the batterer's profile.
Okay, what happened then was we were talking, and after he explained to me what happened, then I told him what Nicole said had happened. And I told him that Nicole had advised me that he had hit her. And that after looking at the profiles, she felt that they all fit him to the T.
Sustained. Hold on. Curious to disregard any comment by the witness as to what Nicole Brown Simpson said at that time. Mr. Darden. No.
Well, I'm a little confused as to what's in and what's out now.
Sure. that, just that portion. From the part I told him what Nicole said had happened, and I told him what Nicole had advised. That's all stricken. Anything this witness just said that was said by Nicole Brown Simpson is stricken as hearsay.
Okay, without telling us what Nicole told you and what you told the defendant, what was the defendant's reaction?
At the time, after we went over all the profiles, he denied that any of those were him, except for maybe one.
And which one was that?
The jealous. He said maybe I might be a little jealous, and that was it.
Read to us exactly what the profile says about jealous.
So,
Let me see that. Thank you. And do you have a copy of this, Counsel? Well, they don't have their copy here. Mr. Darden, I'd feel more comfortable if you ask the witness one additional foundational question regarding whether or not that was actually discussed. Second item.
Mr. Chair, showing you page 2 of the document, directing your attention specifically to lines 3 and 4. Defendant discuss specifically those two lines?
just the pathologically jealous.
Is that what the profile says, pathologically jealous?
Yes, it does.
You and he discussed that.
Well, that's the only one that the defendant said, I might be a little. He just said maybe. He didn't really say, I am jealous. He said maybe, a little bit that one.
He said he may be pathologically jealous. Is that correct?
That's correct.
Did he express to you at all that he was concerned about Nicole Brown's physical well-being?
Yes, he did.
What did he say?
Well, he had, he said he loved Nicole and he would never do anything to hurt her. And it was just an isolated incident.
Now, at that point, I'm sorry, he said what?
He said it was an isolated incident.
Now, had you read anything in the newspapers up to that point that is about the January 1, 89 incident?
In the newspapers?
Yeah.
No, it hadn't been made public then.
At some point, was it made public?
Yeah, I can't remember if it was a week or 2 weeks. It wasn't until like a week and a half later afterwards.
Well, after it was made public, did you have a discussion with the defendant again?
No, but yes, I did. I'm sorry. I did afterwards.
After it became public?
Okay, give me 1 second. Let me think about this 1 second. No, it was before it was made public. I had a discussion with him.
And did that discussion was it in regard to publicity?
Yes, it was.
What did the defendant say about that?
Well, at the time, he was very upset because he thought that, he was going to lose Hertz and his image was going to be tarnished. And he was just asking me to tell Nicole, hey, this is never going to happen again. And, that he loved her.
Well, the city attorney was considering filing charges at that time, correct?
Correct.
Did he ask you to say anything to Nicole about filing charges?
Yes, he had asked me to get to see if I could have her sign off the report, not press charges.
He asked you to see if you could get her to sign off the report?
Yes, he did.
And what does signing off the report mean?
Meaning saying that if she were to sign it, that she was not agreeing that he, had actually battered her, that she didn't want to go through with the actual crime report and have it go through the process of the city attorney's office.
Did you ever contact the city attorney's office on the defendant's behalf?
Never.
Did you ever speak to any supervisor in the LAPD on the defendant's behalf?
Yes, I did.
Why did you do that?
Well, here once again, I was caught between a rock and a hard place, and I was wanted to try and help OJ out, but at the same time, I felt that I didn't want to do it because of what I knew as far as, that type of relationship. But I brought the paper over to her.
Overruled.
Someone asked you to bring the paper to Nicole?
Yeah, OJ did.
And what is this paper that you're referring to?
What I remember, it was a document. I can't remember what the actual wording is. It was something to the effect that, I do not wish to press charges at this time. Something like that. I can't remember.
Okay, but you were a member of the LAPD at that time, is that
Right.
correct? Warren police officer.
Right. Yes, I was.
And you did take it to her.
I took it to her.
Did she sign it?
No, she did.
To go back to the issue of whether you contacted any supervisors on the defendant's behalf, did you contact any of your supervisors at the LAPD?
It wasn't my immediate supervisor, but it was the supervisor that was handling the case,
And who would that be?
Lee Kingsford.
And was he in the detective section at West LA Station?
Yes, he was. He was the Detective 3.
That's the supervising detective.
Yes.
Okay.
Yes, it is.
Now, did someone ask you to contact the supervising detective at LAPD?
No, I wasn't specifically asked to contact an individual. It was just to, hey, Ron, can you get this taken care of?
Or did the defendant tell you how or what to do to take care of it?
No, I didn't.
Or what was your understanding of that request? What did he mean by take care of it?
If I could,
Overruled.
if I could take the, if I could bring the document that Nicole would sign it, because at the time, Nicole wasn't sure what she wanted to do.
Okay. Yes, thank you, Ron.
generally an objection, as well as my 403 objection.
All right, we've dealt with those.
Very well.
All right, thank you, counsel. All right, let's have the jurors, please.
Witness be taken to stand.
Yes. All right, let the record reflect that we have been rejoined by all the members of our jury panel, that Mr. Shipp is again on the witness stand. Mr. Shipp, you're reminded you're still under oath. Mr. Darden, you may resume your direct examination.
Thank you, Your Honor. Good afternoon, sir. Good afternoon. Mr. Shipp, a little while ago, you told us that you spoke to a detective in an attempt to see if you could take care of this situation for Mr. Simpson.
Yes, I did.
During 1989, did the LAPD have a policy as it related to the arrest of spousal abuse suspects?
Yes, they did. It was 273.5 PC, Penal Code.
Now, is this something that you taught during your domestic violence classes at the police academy?
Yes, it was.
Okay. And what was that policy?
The policy was what the law did was most victims, when they're in a bad relationship, have a tendency.
Mr. Shipp,
I can explain this.
the question is, what was the policy, not
Okay,
why?
all right, the policy. I'm sorry. The policy was to make an arrest if there's any kind of injury.
So anytime there's some indication that a victim has suffered some injury in a spousal abuse situation, the policy required the LAPD officer to arrest the suspect.
Yes, it did.
Anytime there was an injury.
Anytime there was any kind of a willful injury by the actual suspect or batterer.
Now, you told us that you heard on Monday, June 13, that Nicole Brown was dead. Is that right?
Yes, I did.
And where were you when you heard the news?
I was in a bank, the First Interstate Bank.
And what did you do at that point?
I called the house,
Whose house?
OJ Simpson's house.
Did the defendant, did he answer the phone?
No, I did not.
Did you go to the defendant's home?
Not at that time. Not at that time, no, I did.
At some point that day, that Monday, did you go to the defendant's home?
Yeah, I went there. I think I went there like maybe an hour or two afterwards, a couple hours, if I'm not mistaken.
And was the defendant at his home when you arrived?
No, he wasn't.
Do you recall what time it was when you arrived at the defendant's home?
The first time, it might have been roughly around maybe 2 o'clock, somewhere around there. I'm not really sure. I went there twice that day.
So you arrived at 2 o'clock Monday, the first time, right?
Right.
The defendant wasn't there.
No, he wasn't.
Did you go to his house a second time that same Monday?
Yes, I did.
What time was that?
I think it's approximately 5:45 to 6 o'clock.
Okay. Do you know where the defendant was at 2 o'clock on that Monday?
I had no idea.
Well, when you went to the house the second time that evening, was he there?
Yes, he was.
Did you just walk into the house as you had on prior occasions?
No, once again, I pushed the buzzer.
You were buzzed in?
I was buzzed in.
Who buzzed you in?
I can't remember. There was, like maybe 10, 15 people there at the time.
Okay, so you walked into the house and there were 10 or 15 people there?
Yeah, around the, different parts of the house.
Who was there?
What I remember at the time, I remember there was, if I'm not mistaken, I think Kathy Randall was there,
Okay, and who was Kathy Randa?
OJ's assistant.
Who else?
I remember there was Jason, if I'm not mistaken. There was Arnell.
Is that Jason and Arnell Simpson?
Yeah.
The defendant's two adult children?
Yeah, I mean, I was there over a week's period, so I mean, this is what I'm thinking on that night. There was also.
Well, resume, please.
Can we approach again?
For what purpose, Mr. Stern? I don't think it's necessary at this point. We're in the middle of a question.
There's still a witness present.
Thank you, counsel. All right, Mr. Stern, you may resume.
When we left off, Mr. Shipp, you told us that Kathy Randa and Jason and Arnell Simpson were present in the house that evening. Is that correct?
What I remember, yeah, I think they.
Okay, who else was present?
OJ's sisters were both there, and brother-in-laws, his mom, and I think there was grandkids there. I think a couple of OJ's friends, I think Joe Stellini was there, Neil Sloan. I'm not sure if Bob Kardashian was there. I'm not sure if he was there. I think he was. I'm not real sure.
Robert Kardashian, seated
Yes,
here?
Robert Kardashian. And I think there's one guy there. I'm not sure if it's one of OJ's golfing buddies or whatever that I remember.
You recall that person's name?
I can't remember his name.
What are the names of Mr. Simpson's two sisters?
Carmelita, and I'm sorry, I'm drawing a blank again. I can't think of his other sister's name right now.
And the two brother-in-laws, what are their names, if you
I
know?
can't remember.
And you said that someone's grandchildren were there?
Oh, excuse me, it might have been OJ's nieces, I'm sorry. Nieces were there.
And do you recall their names?
No, I can't remember.
Recall their ages? Approximate?
Or early 20s, maybe? Early 20s?
So, how many of them were there? How many nieces?
2.
Now, did you testify a while ago that you arrived the second time at 6 o'clock?
Yes, I did. Between 5:45 and 6.
And what time did you leave?
Maybe about 11.
Now, when you arrived at the house around 6 o'clock p.m., did you go to a particular room or part of the house?
Yeah, I guess you would call it his TV room.
Were there other persons or people in the TV room?
Yeah, that was myself. Like I said, Joe Stellini, Neil Sloan, and I think Robert Kadash. I'm not sure. I can't remember.
And was the television on at that time?
Yeah, I think there was either 3 or 4 of them on.
Okay. And did you notice anything unusual about the defendant's hand that time?
Yes, I noticed that he had one of his on his left hand. I think one of his fingers was bandaged, white bandaged on it.
Okay. And did you pose any question to him at that time?
Yes, I asked him how he cut his hand, how he cut his finger.
And what did he say?
So he did it in Chicago.
Chicago?
Yes, he did.
At some point, did the defendant prepare to go upstairs to go to bed?
Yeah, after a few hours,
And what did you prepare to do at that time?
go home.
If you know, where is the defendant's bedroom located? Where in the house?
Upstairs, located on the far east section of the house.
Have you ever been in the defendant's bedroom?
I think maybe once or twice prior to that night.
Now, as you prepared to leave the defendant's home, did you walk toward the front door?
Yes, I did.
And where was the defendant at that time?
Walking towards the stairs
Stairs leading up upstairs to his bedroom?
up to his bedroom.
And did he say anything to you at that time?
Yeah, he said, Ron, come upstairs for a minute.
And did you go upstairs?
Yes, I did.
Did you go upstairs with the defendant?
Yes, I did.
Did you and the defendant go to a particular room?
To his bedroom, yes.
And what was the first thing that you did when you entered the defendant's bedroom?
The first thing I did at his request was to open the cabinets where his TV was.
And what was the defendant doing while you were doing that?
Starting to get undressed.
What was he wearing initially?
I think he was wearing a white shirt and I can't remember what color the pants were.
Was he wearing pants?
Yeah, he had pants on.
And did you watch the defendant as he undressed and prepared to get ready for bed?
I mean, I didn't just stare at him, but I just, I was looking at TV and we were talking, you know.
All right. Okay. Did he take his clothes off, his pants and his shirt off?
Yes, he did.
Okay. What did he do with them after he took them off?
He folded them, and I can't remember if he hung them up or if he just laid them down, but I remember he was very meticulous as to how he was taking off his clothes and being very neat.
And he's always been that way, hasn't he? I mean, neat with his clothes.
Yeah. Yes, he has.
And so what happened next? What happened after the defendant neatly folded his clothes?
He began to ask me a couple questions.
What was the first?
No, excuse me. I take that back. The first thing he said, he told me what the police had done when they came out to his house.
And what did he tell you the police had done when they came out to his house?
He said that they had gone through everything, and then they told him that they had found a bloody glove. They told him something about a watch cap, something like that, and that they had, what was it? So that's all I can remember at this time.
And did he ask you any questions?
Yeah, the record.
Yes, with recording.
With the recorder.
All right, Mr. Darden?
When we left off, Mr. Shipp, I'm sorry.
Do you wish to voir dire the witness at this point? All right.
We're not at that point yet, Your Honor. I have additional questions.
All right, the objection's overruled. Briefly, Mr. Douglas.
Not at that point yet, Your Honor.
That's for me to determine, Mr. Darden. Mr. Douglas?
Thank you, Your Honor.
You said that you arrived at the Rockingham location the second time, sometime around 5:45 or 6, correct?
Roughly around there.
And did you say that it was sometime around 11 o'clock or so that you met with Mr. Simpson in his bedroom?
If I'm not mistaken, I think it was somewhere around that time.
Do you recall, sir, that in fact you left Mr. Simpson's home sometime around midnight that day?
Objection, that assumes facts not in evidence.
We're not, yeah, correct. That question.
Question stricken, Your Honor?
No, question's not straight. Mr. Douglas?
Do you recall, sir, that you left the Rockingham home escorting Kathy Randa to her car?
Same objection, Your Honor.
Overruled.
You know, one of the things, okay, as far as
The question is, sir, do you recall escorting Kathy Randa to her car?
Can
I was
the
there for a
witness be
full
allowed to-
week.
Hold on, wait a minute. Counsel. Mr. Darden, please.
Witness, he's interrupting the witness in the middle of his answer.
Well, if you wouldn't interrupt me, maybe I could hear what's going on.
Well, I can't hear what's going on either, Judge.
Mr. Douglas,
Thank you, Your Honor.
this is beyond the bounds of regular voir dire, though,
Very well.
as far as foundation is concerned. I don't hear foundational questions here.
When you went up to Mr. Simpson's room, isn't it true that Shirley Baker, his sister, was there?
in the room?
Correct.
No, it's not true.
Not an appropriate line of questioning under 403.
I'm going to give you a couple more questions, Mr. Douglas, but we're in cross-examination. We're not in voir dire at this point.
Yes, Your Honor. When you had the conversation with Mr. Simpson, you and he were alone?
Yes, we were.
When you had the conversation with Mr. Simpson, wasn't he already in bed?
No, he was not.
When you had the conversation with Mr. Simpson, wasn't his sister there in the room?
No, she was not.
It's your testimony that you and Mr. Simpson were present alone together, correct?
By ourselves.
One moment, Your Honor. I'll reserve my questions for later, Your Honor. Thank you very much.
Mr. Darden.
When we left off, Mr. Shipp, I believe you told us that the defendant told you that the police told him that they found a bloody glove. Is that correct?
That's correct.
And they also said that they had found a watch cap or something somewhere?
They said they found a watch cap on the property.
Did you and the defendant discuss things unrelated to Nicole Brown's death?
Unrelated to her death?
Unrelated.
Not at this time.
Did you know that the defendant had gone down to the LAPD headquarters that day?
Yes, I did.
And did you and the defendant discuss what occurred there?
Not at all.
Well, did he ask you any questions? Any questions about the investigation that night?
After he told me about what they found at his house, he asked me how long does it take DNA to come back.
And at that time, did you know the correct answer to that question?
I did not know the correct answer, but what I did say, I just off the cuff said 2 months.
And what did he say in response to your indication that it takes DNA 2 months to come back?
He kind of jokingly just said, you know, to be honest, Ship, that's what he called me, Ship. He said, I've had some dreams of killing her.
Did he say how many dreams he'd had of killing her?
No, he did not.
Did he say it was more than one?
He just said dreams, plural.
You were interviewed by the LAPD back in June or July of 1994, is that correct?
That's correct.
And did you reveal to the LAPD at that time that the defendant had told you that he had had dreams about killing Nicole
No, I did
Brown?
not. No, I did not.
Did the detectives ask you about your conversation with the defendant, if any, on June 13th?
They asked me if I had one, but at the time I did not. No, I did not tell them.
You didn't tell them?
No, I did not.
Well, you're an ex-police officer, right?
Yes, I am.
You understood that they were conducting a homicide investigation, correct?
Yes, I did.
But what was your reaction when you heard the defendant say that he had had dreams about killing Nicole Brown?
Sustained.
It's going to explain his subsequent conduct, Your Honor.
What he did after he heard it.
Well, after the defendant told you that he had had dreams of killing Nicole Brown, did you tell anyone else immediately?
That night I went back and told my wife.
Were there other persons present in the house at that time? That is the time in which you heard the defendant say that he had dreams?
Other people present?
Yeah.
Yes, there were.
There were other people in the house downstairs?
Downstairs, right? Correct.
Did you go downstairs and tell those people?
No. No, I did not.
And you didn't tell the police detectives when they questioned you?
No, I did not.
Why didn't you tell the police detectives about the defendant's statement that he had had dreams of killing Nicole Brown?
At the time when Detective Van Adder approached me on the situation, you got to understand I was in a state of shock for up until that time, and I wanted nothing to do with any of this at the time. I was just still thinking it was a dream, like most of America.
Or did you think that you could somehow hurt the defendant or harm him or by disclosing that information?
Pardon me?
Did you think
Yes, I did. I felt it was harmful.
Well, why didn't you just tell the detectives?
I didn't want to tell the detectives at the time. I didn't even want to talk to them. I wanted nothing to do with it. I just wanted everything to go away. I wanted nothing to do with this. I've been a civilian, I think at the time, for almost 5 years. I'm living a normal life.
did the fact of your friendship with the defendant enter into your decision not to tell the detectives?
Yes, it did.
How?
Like I said earlier, I mean, I've loved this man for 26 years. And all of a sudden, you know, my thought process, like I said, I wanted nothing to do with it at all.
Are you acquainted with someone named Sheila Weller?
Yes, I am.
And who is Sheila Weller?
Sheila Weller is an author of the book Raging Heart.
She's the author of a book called Raging Heart.
Right.
Have you read that book?
Most of it, not all of it.
Were you interviewed by Sheila Weller?
Yes, I was.
Were you interviewed by her for that book?
Yes, I was.
And when were you first interviewed by Sheila Weller?
I think it was in July.
July of 1994?
Correct.
How many times were you interviewed by her?
Maybe 6, 7 times. Maybe a little more, I can't remember.
Did you tell her about the defendant's statement? The statement that he had dreams of killing Nicole Brown?
Not the first time when I talked to her.
Did she ask you about your conversations with the defendant on June 13?
She didn't know about it then.
Okay. Now you say that you have read this book, Raging Hearts, or rather most of it.
Yes, I have.
And there is a scenario in the book that describes someone who in the book is called or named Leo. Is that correct?
Yes, it is.
Have you read that passage?
Yes, I have.
And are you the Leo?
Yes, I am.
Are you Leo, the Leo who's described in that book?
Yep, that's me.
Is the bedroom conversation you just described to us today described in the book?
Yes, it is.
So you told Weller about the bedroom conversation.
Yeah, later on I did.
When, if you recall?
Maybe, I think it might have been maybe a month afterwards.
A month after the
After
killing?
the first time that I talked to her.
So what month would that be?
I guess August.
Okay. Well, had you told the LAPD about the defendant's statement regarding his dreams?
No.
So you told Weller before you told the LAPD?
Yes, I did.
You told Weller before you told Marshall Clark or myself?
I sure did.
Why'd you tell Weller about the dreams before you told us?
Ever since I heard that conversation, it was just eating me up. And I knew I didn't want to tell you guys because I didn't ever want to be in this position when I'm talking about this. And I had to get it out. And that's why I told her originally this whole thing was I was going to be anonymous.
You told Sheila Weller about the conversation and asked that you remain anonymous?
Yes, I did.
Okay, so your name isn't Leo. Your real name isn't Leo.
No, it is not.
And people refer to you as Ron. Is that
Yes,
right?
they do.
Did Weller agree to keep you anonymous in the
Yes,
book?
she did.
Did she offer you money in exchange for your telling her this information?
Not at all. Only reason I agreed to do the book, I got a call from Rolf Bauer, Nicole's brother. I mean, actually, he's her cousin. And originally, I didn't want to do it at that time. He asked me to interview with her.
Correct. Next question.
Okay, so you were never offered money in exchange for
Never. Money was going to Sydney and Justin. That was all I was told, that they would donate a nice substantial amount to Sydney and Justin.
Okay, so if I understand you correctly, then money from the sale of the book was going to go to the defendant's children?
Right. Correct.
None was to go to you
Not a dime.
or any other person?
No one in my family, no one. I mean, there was no mention for money for me at all.
Have you ever accepted any money in exchange for your testimony or in exchange for your recounting the information
Never.
you've given us today? Never?
Never.
You've never accepted any?
None.
You given any television interviews?
None.
Spoken to the tabloids at all?
No, I have not.
Now, at some point, you did tell Detective Van Adder and Detective Lang and myself about this conversation. Is that correct?
Yeah, just recently.
And that was January 21, wasn't it? Is that correct?
That's correct.
Did anyone force you to disclose this information to Sheila Weller
No, not at all.
or to us?
No.
You knew the book would be published at some point. Is that correct?
Yeah, I did.
And were you told that the conversation you had with the defendant would be included in the book?
Yes, I was.
Were you concerned at all that others might read that scenario, try to identify the person who is described as Leo in the book?
Yes, I was.
Were you concerned that someone else might read the scenario in the book and realize who Leo really was?
Yes.
Who?
You guys.
Were you concerned at all that the defendant might read the book?
I would think he would be told about it. If he did not read it.
I have one moment, Your Honor. You consider yourself a friend to this defendant?
You can answer the question.
I do. I don't know how he feels.
Thank you, sir. No further questions, Your Honor.
Mr. Douglas?
Mr. Chair. What did you review in preparation for your testimony today, sir?
Only thing I ever looked over was the domestic violence profiles.
Now, it is true, is it not, that you have given a few statements about information that you have concerning this case. Isn't that correct?
Yes, I have.
You were interviewed in the district attorney's office in July. True?
That's when it was. Okay.
And that would have been July 28th, 1994. Sounds about right?
I guess. I don't know what the date was.
You do remember giving that interview in July?
Yes, I do.
Was that interview before or after your first interview with Ms. Weller?
That interview, I think it may have been afterwards.
You think that the first interview with the police department was after the interview with the author?
Now, you said with the
Correct.
police department or with Marsha Clark and
Well,
which one?
police officers were present in Marsha Clark's office, were they not?
Yes, they were.
Officer Van Adder was present. True?
True, but I talked to Phil before I even talked to Marsha and Bill Hodgman.
You talked to Phil before talking to Marsha. Marsha is Marsha Clark,
Yes, Marsha Clark.
and Phil is who?
Phil Van Adder, detective.
You and Phil go back a while, don't you?
Yeah, we've known each other over the years.
And how about you and Marcia?
First time I ever met her.
And Bill was also present at that interview.
Yes, correct.
Remember Bill?
Yeah, I remember Bill.
Bill Hodgman. Okay. Now, you spoke with Phil and Marcia and Bill for about 90 minutes, didn't you?
Whatever you say.
Sound about right?
Okay. Yeah.
And they asked you everything that you knew about your relationship with Mr. Simpson, did they not?
That's correct.
And in fact, there was somebody taking down transcription, everything that was said, wasn't there?
That's correct.
Were you placed under oath during that interview
No, I
with
was
Bill and Bill and Marcia?
No, I was not.
Now, have you ever had occasion to read the statement of that interview, which is 60 pages long?
Yes, I did. I read portions of it.
You read that when I gave it to you, didn't you?
Sometime afterwards. I didn't read it immediately.
Right, because sometimes after meeting with Phil and Bill and Marcia, you met with Mr. Douglas, didn't
That's
you?
correct.
Remember that?
Oh, yes, I do.
And you and I met in your attorney's office,
That's
didn't
correct.
you? Remember that?
Yes, I do.
And that would have been about September the 9th of 1994, correct?
If that's what you say, I don't know the dates.
And during withdrawn, we met in your attorney's office for about 2 hours, didn't we?
No, we did not.
How long did it last?
45 minutes.
And during any time withdrawn, you knew on that occasion that I was representing Mr. Simpson, didn't you?
Yes, I did.
I gave you my business card, didn't I?
Yes, you did.
In fact, after that interview, you called me back later, didn't you?
Did I call you or did you call me?
I called your home after you had called and left the number. Recall that?
If you say so. Okay, I can't remember.
During any part of the 45 minutes that you and I spoke, did you ever mention anything about this conversation with Mr. Simpson?
No, sir.
Didn't I ask you during that conversation to tell me the worst things that you knew about OJ Simpson?
Yes, you did.
And wouldn't you agree that this statement about this supposed dream is a pretty bad thing about Mr. Simpson?
Yes, it is.
So did you lie when you didn't tell me about that dream?
I sure did.
You did. You've lied a few times, haven't you, sir?
Never in court. Never.
But you've lied a few times concerning what you know about Mr. Simpson. True?
Yeah, I'd say.
You lied to Marcia, didn't you?
Well, if holding back information, they never asked me about that. If holding back information is lying, I don't think it is lying. I just didn't tell them everything.
Well, you just didn't tell the police and the district attorney about an important conversation that you claim occurred. True?
That's correct.
Now, the first time, withdrawn, sometime before talking with me, you had a conversation with an investigator working on my behalf, did you not?
Yes, I did.
Mr. Joe Brown, recall that?
Oh, okay. I was thinking of Hostetler. I'm sorry. Mr. Joe Brown. Okay, I did. You're right.
And you never told Joe Brown about this supposed conversation with you and Mr. Simpson, did you?
No, I did not.
So let me get this straight. You met for 90 minutes with Phil and Marcia and Bill and never mentioned this conversation, correct?
Never did.
You met for 25 minutes with Joe Brown and never discussed this conversation, correct?
Did not.
You met with me in your attorney's office for 45 minutes and never talked about this conversation, correct?
Correct.
And you are Mr. Simpson's friend as far as you think, correct?
Yes.
Now, you've said that the reason why you didn't tell Phil about the conversation was because of what?
I said I didn't tell Phil because at the time I really did not want to be really involved in all this. And I didn't want to be going down as being the person to nail OJ.
Well, let me ask you this. Well, you're not, so don't worry about that. But let me ask you this.
Objection to editorial.
Sustained. Counsel, you know better.
Sorry, Your Honor.
Curious to disregard counsel's remark.
When you talked to Miss Weller about this supposed conversation, did you want to remain anonymous then?
Yes, I did.
Did Miss Weller inform you that she was writing a book?
Yes, she did.
And did she suggest to you that your conversation would be in the book?
Yes, she did.
And did you interpret by the fact that your conversation would be in the book that you would no longer be anonymous?
Well, I felt the only ones that would know about that conversation would be me and OJ.
I see. Wouldn't anyone else who was present at Mr. Simpson's home when you went upstairs, as you say, also know who you were in relation to your identity?
Possibly.
So I understand your version. There was a time when Mr. Simpson went to bed, correct?
Correct.
And this was a man that had just lost the mother of his children, correct?
Correct.
And he was grieving that evening, wasn't he?
Define grief.
He was in grief, wasn't he?
This witness is incompetent to fire this.
I think it's a common human condition that he can testify to. Overruled.
You may answer.
At the time when I talked to OJ, as far as when you say grieving, crying and stuff like that,
Wasn't he feeling bad about his wife's death, Mr. Shipp?
Objection to that call.
Overruled. You can ask to describe demeanor.
Can Mr. Darden be the one to object, Your Honor?
So much objectionable material.
Counsel, you don't need to say that. Juries to disregard that comment by counsel as well.
Now, Mr. Simpson wasn't in a good mood.
no, he was not.
Okay. He was surrounded by his family, correct?
Yes, he was.
He was surrounded by his close friends, correct?
Correct.
Family were concerned about his emotional state, were they not?
Sustained.
Yes, they were.
Motion is granted.
Oh, I'm sorry. Excuse me.
Is there any real dispute about that? Family and friends are there. All right.
Yes, they were.
All right.
When Mr. Simpson retired for the evening, did you have occasion to see his family wish him a good evening?
When I was leaving?
No. You said that Mr. Simpson was retiring for the evening, correct?
Correct.
And he asked you to walk upstairs with him, correct? Do you remember family wishing him good night, sleep well, pleasant dreams, or something of that nature?
Not at that time, no.
Did you remember that he snuck upstairs without anyone else in the room noticing?
He snuck upstairs?
Yes.
I don't remember that.
Okay. So it wasn't a secret when he went to sleep that evening, true?
No, everyone knew he went to bed.
Okay.
'Cause I was asked by Shirley to unplug the phone.
So everyone knew he was going to bed and that you were going upstairs with him.
Yes.
So it wasn't a secret that you were going upstairs with Mr. Simpson when he was going to bed.
No, I wasn't.
Okay. So that if there would be revealed in some subsequent book a conversation that occurred on June 13th when Mr. Simpson was going to bed, you knew that the people in that room could identify you as being the source of that conversation. Correct?
Correct.
So you didn't really have a concern about being anonymous, did you, sir?
Well, like I said, I felt that I felt OJ would know. And at the time, when I told Sheila about this, there were several people, of course, there at the house. And I was thinking, hey, no one would really maybe put two and two together.
I see. Now, you were a police officer for how many years?
15 years.
And during the course of your 15 years as a police officer, you investigated crimes, I would assume.
I did.
And would there be occasions that you would read descriptions about events in either newspapers or books that would assist your investigation of a pending crime?
Yes, I'd say you're correct.
So it was not unsuspecting of you that if some police officer were to later read about a conversation in a book concerning a conversation that may have occurred with OJ Simpson, that someone later would investigate the source of that conversation. True?
True.
So you knew, Mr. Shipp, that by having this conversation with Miss Weller, that you would not be able to assure your anonymity. correct?
Mr. Douglas, I'd say you're probably correct.
Prior to the book being released, did you have occasion to review a draft of the manuscript concerning your conversations with Miss Weller?
Yeah, I did.
How many times?
Well, once. I looked it over once.
When in this series of 6 or 7 occasions that you and she met, did you review a draft?
I didn't review it at all at the time when she took the notes.
No, I'm asking when, during the course of these 6 or 7 times that you met with her, did you review the draft?
I assume that.
I thought I just answered that.
Did you ever review the draft text of what she said that you said? to
Not
her?
during the 6 or 7 times when I met with her.
When did you review that draft, sir?
Probably maybe 2 weeks before it came out.
And did you have occasion to offer any corrections?
Yes, I did.
And did you offer corrections?
Nothing. Yes, I did.
Were the corrections ultimately made?
Yes, they were.
You've had occasion since the publication of that book to read the version applying to you.
Yes, I have.
Is it accurate?
Yeah, just about everything's accurate. Yeah, I'd say it is.
I'd like to show the witness, Your Honor. Copies of a document that I'm going to have marked as defendant's exhibit 1000. And I'm writing D1000 in the upper right-hand corner.
And what page are you starting
I'm
on?
beginning at page 8, Your Honor, and it goes until page 12.
Right.
First of all, Mr. Shipp, looking at the document that has now been marked as Defendant's Exhibit 1000, does that appear to be the relevant pages of the book Raging Heart by Miss Weller?
It appears to be. Yes, it does.
And there appears to be some reference to the conversation that you had with Mr. Simpson, supposedly, beginning on page 9, correct?
Yes.
Was it in any way withdrawn? Let's talk about the conversations that you had with Miss Weller. You say you spoke to her the first time before talking with Marcia and Bill and Phil, correct?
Yes, that's correct.
And how much time did you spend with Miss Weller the first time that you spoke with her?
Maybe 2 hours
Did you talk in person or on the phone?
in person.
How'd you get your number, if you know?
From Ralph.
Did you have occasion to speak with Rolf about your supposed conversation with Mr. Simpson before you met with Miss Weller?
Did I tell him?
Correct.
No, I did not.
When you met with Miss Weller, where'd you meet?
At Yamashiro's.
You and she had dinner?
Hors d'oeuvres.
Anyone else present?
Waitresses.
At the table with the two of you, I'm asking.
No, no one else.
And at the conclusion of the first meeting, did the two of you agree to meet again?
Yes, we did.
After you met with her the first time, did you like her?
Yes, I liked her.
Did you feel some sort of kinship with her?
Kinship?
Correct.
I thought she was a nice person, yeah.
Did you feel that you could trust her?
Yes, I did.
Did you feel that you could trust her more than you felt that you could trust the police department?
That's not a thing of trusting the police department. I felt I could trust her as far as not printing my name in a book.
But you were going to trust her with some information that you didn't tell the police.
That's correct.
Were you not?
That's right.
You were going to trust her with some information that you hadn't told the district attorney, correct?
That's correct.
When did you develop that quality of trust in her that you were comfortable sharing something with her that you had not shared with the police?
Maybe, I don't know, maybe the third time I met with her.
The third time you felt that comfort. And where had you met with her the second time?
Most of the time we met, it was at Yarmouth Shrills.
Each of the times?
Yeah.
How much time passed between the first time and the second time?
Oh, maybe a couple of days.
Couple of days. When you met the first time, who picked up the tab?
First time, I did.
And the second time?
I think I did.
And the third
I
time?
think she did.
And the fourth time?
But I think she may have.
And the fifth time?
We weren't always eating. You know, we never had dinner. We were just basically just having hors d'oeuvres. And
Did you and Miss Weller ever sign any documents concerning your interview with her?
yeah, we signed a document saying that she would not reveal my name
Where's your copy of that document?
in my house.
Could you bring it with you tomorrow?
Sure
Can you
could.
come to court?
Yes.
Thank you. And how many pages does that document consist of?
One.
One page? And what does that document say as best as you can recall?
I can't remember.
Tell me all that you can remember that it says.
Something I, Sheila Weller, would promise not to reveal your name. Something like that.
Was that document signed by Miss Weller and by yourself?
Yes, it was.
And it was dated?
I think so.
Okay. And during which of the 6 or 7 occasions that you and she met did you sign that document that we've just discussed?
I think it might have been the first. Once I agreed to start talking to her, I think she wrote it up.
In your mind, was the most important thing for your comfort that you be anonymous?
Yes.
If you had not had a promise of anonymity, in your mind, were you prepared to share intimate secrets about Mr. Simpson with a total stranger?
Mr. Douglas, sometimes when people are going through stuff, sometimes they say things that they really want everybody to know.
That's not my question, sir. My question is, in your mind, were you prepared to share intimate secrets about your friend to a total stranger without the promise of anonymity?
Oh, no, no.
So the promise of anonymity was the reason or the motivation for you to share intimate secrets with your friend to a total stranger.
Correct.
Have you in the past shared intimate secrets about a friend to somebody writing a book?
Never.
Never before.
Never.
Have you in the past lied to police officers about a murder investigation?
Never.
Never before. You say that the conversation with Mr. Simpson was eating you up. Is that your statement?
That's correct.
And did you hope to exorcise this pain from your body by talking to Sheila Weller?
Yes, I did.
You didn't think that you could exorcise this pain from your body by talking to the police department?
Well, at the time, truthfully, no, I did not. I did not want to put them in a certain situation, knowing their profession, how professional these guys are.
You didn't want to put the police in the position of knowing information that you thought was important concerning the deaths of Nicole Brown Simpson?
Well, I know if I would have told Phil, okay, hey, Phil, confidence, you know, I want to share something with you. There's no way in the world Phil would have said, yeah, Ron, I'm going to bury this. So
But you did know that when the book came out, Phil would be able to figure it out. True?
like I said, I figured somewhere along the line, yeah, they'd know it was me.
So sooner or later, they'd have to find out.
Sure.
Did you think that you could rid yourself of this pain by talking with the people who were prosecuting Mr. Simpson
I have.
after the book came out?
Maybe a day or two before.
Since you realized that it would probably occur that your identity would be disclosed during the police department's investigation of the allegations in the book, why didn't you talk to the police after talking with Miss Weller, immediately after talking to Miss Weller?
Like I said, Mr. Douglas, at the time, I just did not want it to be down on record on what I thought, my personal feelings, what I thought about Mr. Simpson.
Because you didn't want to be a witness in this case?
You're absolutely right.
Isn't it true, sir, that you were hopeful that you would be able to garner some publicity by making up false allegations about Mr. Simpson?
No, it's not true at all.
Didn't you think, sir, that by concocting this story about Mr. Simpson, it might enhance your own personal profile?
Mr. Douglas, I put all my faith in God and my conscience. Since Nicole's been dead, I've felt nothing but guilt, my own personal guilt, that I didn't do as much as I probably should have.
But let me ask you this. Didn't you think that by being a witness in this case, it would enhance your own personal profile?
No, sir.
Aren't you an actor?
Sir, I have done some acting. Yes, I have.
Let's talk about that. How much acting have you done, Mr. Shipp?
I've done almost a bunch of bit parts here and there.
Have you gone to school for acting?
Objection, it's relevant, show.
Yes, somewhat. Let's see where it goes.
Have you gone to school for acting?
Just years ago.
When did you go to school?
I just took a commercial class.
How long did the school last?
6 weeks.
Did the school teach you how to play certain roles?
The commercial class?
Yes.
No.
Well, you haven't just acted in schools or in commercials, have you?
No, I've done others.
Yeah, you've aspired to generate an acting career.
I've acted almost everything I've done. I've played a cop, which is not too hard to do.
But it is a role, is it not?
Yeah, it's a role.
And by playing a role, you're trying to act as if you're something other than the true self.
Like I said, I played a cop. That's not hard to do.
Okay.
So I played my true self a lot of times.
Are you acting now?
Every now and then, I may do a little something here and there.
Isn't it true, sir, that by being the witness who has a conversation with Mr. Simpson, that it is going to possibly enhance your profile around the world?
Objection.
Oh,
You may answer the question.
Mr. Douglas, there's no way, shape, or form that I would sit here and go through all this, put my family through this for an acting career. I could care less if I
That's not
do
the
any
question.
acting.
The question
Your
is,
Honor, the witness is answering the
you
question.
answer the question.
isn't it
We
true?
asked the witness if he finished
Hold
his
on,
answer.
hold on. I think he's finished his answer. Have you finished your answer?
Yes, sir.
All right, Mr. Douglas.
You do realize, Mr. Shipp, that by testifying as you have, you are going to enhance the name of Ron Shipp around the world.
Just like you're enhancing Carl Douglas by being Mr. Attorney
True.
here.
You realize that too, right?
Yes, I do.
So now you're a star as well.
Well, I mean, that's what everybody's, that's what they say. People are going to see you. But that's not why I'm doing this, Mr. Douglas. I'm doing this for my conscience and my peace of mind. I would not have the blood of Nicole on Ron's ship. I can sleep at night, unlike a lot of others.
Thank you, Mr. Ship. Now, how many months passed between your conversations with Miss Weller about this supposed dream and your conversation with any law enforcement authority about the dream?
I don't know, when did I tell her? August, I guess. From August till I told Mr. Darden.
And how did it occur that you told Mr. Darden about this supposed dream?
Mainly, thought that it probably would come up here in court, and I did not want to sit here and lie. Like I said, I've never lied on the stand ever in my life, and I'm not starting now.
So you called Mr. Darden up?
Yeah, I did. I think I did call Mr. Darden up. Yeah.
And did you tell him in that conversation that there was something that you had lied about earlier?
Are you referring, okay, just the fact I didn't reveal the information to Ms. Clark that I lied? Is that line?
Correct.
Okay, well, yeah, I called him up and said I lied.
And what did he say when you called him and said, I had lied earlier?
I didn't use those words, but anyhow, he asked me to come in, and he asked me the same questions you asked me, why did I not reveal?
And who was present during the subsequent conversation that you had with Mr. Darden about your earlier lie?
I think Phil Van Adder.
Anyone else?
I think it was just Phil.
And you met in Mr. Darden's office?
Yes, I did.
And how long did that subsequent conversation take?
I don't know, maybe total, yeah, total 45 minutes. I think just sitting there and having them recorded and stuff like that.
And did you disclose anything else during that conversation that you hadn't said earlier?
Excuse me, other than the Leo conversation?
Other than the conversation about this alleged dream?
May I interrupt and confer with counsel for a moment?
Certainly.
Thank you.
You first called the Simpson home on June 13th, sometime that morning, is that correct?
Yes, I did.
And that was sometime about 10 o'clock in the morning, wasn't it?
Yeah, my mom paged me at around about 10:30.
And upon hearing the news, you tried to reach someone at the Simpson home, correct?
Yes, I did.
And when you picked up the phone and dialed the Simpson home, did someone answer?
Yes, they did.
Who was that?
Mark Furman.
Had you known Mark Furman before June 13th?
Yes, I had.
When Mark Furman picked up the phone, tell me everything that you can recall about that conversation. First of all, what's the first thing that you asked Mark Furman?
Mark.
Your Honor.
He can tell us what he said, but that's about it.
Very well. What did you ask Mark Furman?
I said, Mark, did OJ kill Nicole?
Did you ask Mark Furman about any of the evidence?
No, not at all. That was...
Did you ask Mark Furman whether or not there was a suspect in mind?
Yes. He told me he wouldn't answer me. And he told me, Ron, you know I can't answer you. And I tried to
How-
persuade him, tell him, hey, it's me you're talking to.
How long did you and Mark Furman talk on the phone on that day?
No more than 1 minute
1 minute.
at the most.
Without saying what he said, did Mark Furman explain why he was there at 10 o'clock answering the phone?
So I did ask him if Nicole, I asked him if she was really dead.
Did Mark explain to you why he was there answering the phone at 10 o'clock a.m.?
Yeah, he said he was investigating. That's when he said, yes, she is dead, and he's there investigating the homicide of her and Ron.
He was at Mr. Simpson's home at 10 o'clock investigating the homicide of Nicole Brown Simpson and Ronald Goldman.
Right.
When you returned later that evening, was Mr. Simpson there when you got there?
Yes, he was.
And he was there with his two sisters, correct?
Yes.
And he was there with his two adult children?
If I'm not mistaken, if Arnell was there, I think she might have been in guest house. I'm not sure. I was there for a whole week, Monday through Friday. So some of the days have run into each other.
Do you recall that his mother was there?
Yes, I think she was there. Yes, she was there.
That was a day that was somewhat unusual, was it not?
Very much, yes, it was.
There were media outside the home, were there not?
Yes, there was.
There were helicopters circling overhead. True?
True.
People were inside watching different television programs, correct?
No, everybody was watching the news for the most part.
Different news programs.
Yes.
There came a time, as you've said, that Mr. Simpson retired upstairs to the bedroom,
Yes, there was.
and he asked you to join him, according to your version.
Yes, he did.
And did you and he walk up the stairs alone or together?
Together.
And did you and he then walk into the bedroom together?
Yes, we did.
And it was during this time, while you and he were in the bedroom together, that this conversation supposedly took place.
Yes, it is.
Now, is it your version that Mr. Simpson told you that the police said they had found a glove?
Yes, that's what he told me.
Okay. And did he tell you that they had found a glove with blood on it?
Said, yeah, they said they found a bloody glove, and I did leave out one statement because he did. When Mr. Darden was questioning me, he did ask me, "What does this mean? What does all this mean?"
Now, did he tell you when he had been told that the police had found a bloody glove?
I can't remember.
You knew by the time of your conversation that the police had had an interview with Mr. Simpson.
Yes, okay, he did, yeah. Because he had come from downtown, right?
And
That's
you
correct.
knew that Mr. Simpson had voluntarily gone down and spoken with the police, given a statement.
That's correct.
And you knew that Mr. Simpson had voluntarily returned from Chicago to Los Angeles upon learning of the deaths.
That's correct.
Now, is it your version that Mr. Simpson told you that they also found a cap?
Is it my version?
Did Mr. Simpson tell you that the police had told Simpson that they'd also found a cap?
Yeah, there was two items. I'm pretty sure it was a cap and a glove.
Did Simpson tell you that the police had told Simpson that the police had found blood in the car?
I think he did. I'm not sure. I think he did.
Well, if that statement was written in Exhibit 1000, that Simpson told Leo that the police had found blood in the car, would that statement have come from you, since you're Leo?
That's correct.
Did Simpson tell you that the police had told Simpson that blood was found in the house, in his house?
Yes, he did.
Now, it's your position that Simpson asked you about DNA evidence?
Yes, he did.
Did Simpson ask you about regular blood serological evidence as well?
No, he did not.
Isn't it true, sir, that Simpson never asked you anything about or mentioned to you anything about a cap being found?
Did he never mention it to me?
Correct.
No, it's not true. He
Isn't it
didn't.
true, sir, that Simpson never said anything to you about there being blood found in the car?
No, it's not true.
Isn't it true, sir, that Mr. Simpson said nothing to you about blood being found in the house?
No, it's not true.
Isn't it true, sir, that you mentioned to Mr. Simpson that the police had found a glove on his property?
I had no idea what they found in that house. Nothing.
Didn't you take Mr. Simpson out to behind the garage to show him the area where the glove was supposedly found?
This is sad, OJ. But no, this is really sad.
Your Honor, I move to strike that.
Ladies and gentlemen, you are to disregard Mr. Shipp's direct comment to the defendant. Mr. Shipp,
I'm
please,
sorry, I'm
you're
sorry,
instructed not to do that. All right, ladies and gentlemen, please disregard that. All right, they all nod in agreement.
No, I did not.
Isn't it true, sir, that when you left the Simpson home, you left and walked Kathy Randa out to her car?
Like I said, I was there a whole week. I don't know if it was that night or I've walked a lot of people to their cars.
Well, think hard. June 13th,
No, I walked myself to the car.
you didn't walk Kathy Randa to Kathy Randa's car.
On June 13th? No, because I was so shaken up. I remember I walked by myself and I sat in the car and I was by myself. I remember that because I was very tripped out over all this.
Isn't it true, sir, that you and Kathy Randa walked out together from the first floor, right out the house together, and after you walked her to her car, you then got into your car and left?
Not that night. No.
Isn't it true, Mr. Shipp, that because OJ withdrawn, you are aware that OJ Simpson was very tired that evening, are you not?
That's true.
And you are aware that OJ Simpson was very tired because he hadn't gotten much sleep the night before, true?
True.
Because he had taken a red eye from Los Angeles to Chicago, true?
True.
And then had taken a red eye or taken the first flight, 6 o'clock in the morning, from Chicago back to Los Angeles, correct?
True.
And then because he was on the phone so much, he did not sleep very much on the return flight from Chicago, correct?
Correct.
And as soon as he got back from Chicago, he was then handcuffed by police officers at his home, correct?
From what I saw on the TV, yes.
And then as soon as he got back from Chicago, he was taken down to Parker Center, correct?
Correct.
And after talking with Parker Center, he was then brought back to his house, correct?
Correct.
And then when he returned to his house, his friends, his family were there, correct?
Correct.
And since he hadn't slept for the past 24 hours or so, he went to bed early on June 13th.
No objection.
Didn't
Since
he?
Facts not known, it's called for speculation and hearsay.
Overruled. You may answer the question.
No, he did not.
Isn't it true, sir, that Mr. Simpson didn't go to bed around 11 o'clock, but in fact he went to bed closer to 8 or 8:15 on June 13th, since he hadn't slept the prior night? Isn't that true?
I'm sorry. I lost in the train of thought. Go right ahead again. I'm sorry.
Since Mr. Simpson hadn't slept the prior evening or earlier that day, he went to bed at about 8 or 8:15 on June 13th, didn't he?
No, he did not.
And isn't it true, sir, that his sister Shirley and his brother-in-law Benny Baker escorted Mr. Simpson up to his room and helped him undress on June 13th? Isn't that correct?
Is that what they're going to testify to, sir?
You're in the courtroom.
No, Your Honor, they're outside.
That's not correct. That is not correct.
My statement is not correct.
That is not correct.
And is
All right, thank you, counsel. Mr. Douglas, you may continue.
Thank you. Isn't it true, Mr. Shipp, that from 8:15, the time that Mr. Simpson went to bed, throughout that entire evening, some member of his family sat with him in his room because he was so grief-stricken?
That's not true. Shirley asked me to go stay with him. She didn't want OJ to be alone. She said, "You stay up there with him, Ron."
Now, Mr. Shipp, let me change the subject and talk about your friendship with Mr. Simpson. Were you and he close friends?
I'd say we were pretty good friends. We never went out to dinner like on a regular basis and stuff like that. But
Did you ever go out to dinner with him and you ever?
well, when he was trying to have me help him get back with Nicole, yeah, he was real.
You and he went out to dinner?
He took me out a couple of times.
Where'd you go?
One of the places was right next to his office. I'm not sure if it's the pizza place over there.
You and he went alone to dinner?
Oh, yeah.
What month was that in?
Whenever 1989, whenever, the first week after he and Nicole had the altercation.
When else did you and he ever go to dinner together? In the 26 years that you and he have been supposed friends.
You know, Mr. Douglas, I'm sorry, you're absolutely right. Okay, what he did, he took me out to, maybe it was a late brunch type. It wasn't a dinner, a late brunch type of a thing.
You have never had a dinner in the presence of OJ Simpson alone, have you?
Yes, I have.
OJ Simpson is a football fan, isn't he?
Pardon me?
OJ Simpson is a football fan, isn't he?
Yeah, he loves football. Yes, he does.
He goes to games a lot,
Yes, he
doesn't
does.
he? You and OJ Simpson have never attended a football game together
Never.
in the 26 years that he's been your supposed friend, have you?
Not one.
You and your wife have never gone on a double date with Nicole and OJ Simpson in the entire time that you've known them, have you?
You're absolutely correct.
You and your wife and he and his ex-wife never went to a movie or a play or a concert together, the four of you, have you?
My wife and I were invited shortly after he beat up Nicole.
Move to
Never.
strike that, Your Honor. Non-responsive.
Overruled.
Your wife and you were invited, but you never went, did you?
Never went.
All the times that you claim that you were over his house playing tennis, you have never in your entire life played tennis on the same court with O.J. Simpson, have you?
Never.
You're not really this man's friend, are you, sir?
Well, okay, all right. If you want me to really explain it, I guess you can say I was like everybody else, one of his servants. I did police stuff for him all the time. I ran license plates. That's what I was. Okay, I mean, like I said, I love the guy.
You weren't the kind of friend that he would share some private secret with, were you, sir?
Nothing except for the 1989 beating where he needed me.
You know that Mr. Simpson is an avid golfer, true?
Very true.
You ever been golfing with him?
Never.
You ever asked to go with him?
Never. I'm not that good.
Ever been to a Raider game with him?
Never.
A Trojan game with him? Very well, Your Honor.
Trojan game?
Very well, move on.
When he got a hold of me.
Now, you have had occasion to meet with members of the Brown family since the death of Nicole Brown Simpson, haven't you?
Since the death,
Yeah.
on one occasion,
When was that?
a memorial service for Nicole.
Have you been down to Dana Point to speak with any of the family since then?
No, I have not.
Have you spoken with them on the phone other than on the day of the funeral?
Oh, yes, I have.
How many times have you spoken with anyone from the Brown family on the phone since the funeral until today?
Maybe 6.
When was the last time?
Maybe 3 weeks ago.
Who'd you speak with?
Spoke to both Lou and Judy.
When was the first time?
After the deaths.
Who'd you
Yep.
speak with?
No, I'm trying to clarify.
After the deaths.
I remember I went probably, I didn't want to bother them like, because they were being bothered. So I probably went maybe around 2.5, 3 months before I even called. I mean, I called Rolf all the time, and I'd check on them through Rolf, and I'd ask them how they were doing.
You've spoken with Denise Brown since her sister's death, have you not?
Once at the memorial.
Have you spoken with Dominique Brown since the death of her sister?
Talked to her once, which was also that 3-week period, 3 weeks ago when she answered the phone.
Did you talk to Tanya Brown at all since the death
At
of
the
her
memorial.
sister? I'm sorry?
At the memorial.
You mentioned there were 6 times or so that you've spoken to someone in the Brown family on the telephone. One time was with Louis and Judith Brown.
I talked to Lou a few times a few times I called and I'd asked to speak to Judy or she'd answer the phone and put Lou on the phone.
Did you ever talk to anyone in the Brown family about this supposed conversation with you and Mr. Simpson about dreams?
No, I did not.
Who else have you told before talking to Mr. Darden and Mr. Van Adder? Who else did you talk to about these dreams other than your wife and other than Sheila Weller?
My attorney, Bob McNeil.
Okay.
Robert McNeil, correct.
Washington Boulevard office.
Yeah,
They moved, Your Honor.
he's downtown,
Figueroa.
but he was on Washington. You're correct.
You began the police force when, Mr. Shipp?
November 1974.
And you were a member of the police force until when, Mr. Shipp?
October 1989.
All right, let me see counsel over here at the sidebar with the reporter, please. All right. Ladies and gentlemen, sorry about the delay. Mr. Douglas, do you wish to conclude for the afternoon?
I would, Your Honor, if I may.
All right.
When's the last time before June 13th, 1994, Mr. Shipp, that you had occasion to visit the Rockingham location?
Probably about a week before that.
And that was when you visited there with some blonde female, wasn't it?
Oh, yes, it was.
Yeah, can we post the sign for it?
Yes. I take it there's an objection?
Yeah.
Relevancy? All right, Mr. Douglas, you may wind it up for the afternoon, please.
It is true, is it not, that about a week before the death of Nicole Brown Simpson, you visited Mr. Simpson's house unannounced at about 10 o'clock p.m. with a blonde female. True?
No, that was approximately.
Your Honor, I objected to this question. I thought the court sustained it.
No, overruled,
You may answer.
but with not very broad here.
Very well.
No, the night that the blonde female was over, that was 3 weeks before, who was a good friend of my wife, and we're good friends with her husband. Her name is Lisa Madigan. That was 3 weeks prior.
Is she about 6'1",
No,
resembling Nicole Simpson?
No, she's, I'm sorry. She's about, this is about 5'9", almost 5'10".
Was this the woman who you wanted to share the jacuzzi with?
The fact that he was over there 3 or 4 weeks ago, well, that's about it that's relevant, counsel.
Very well. When you were there on this occasion, did you ask Mr. Simpson to go and bring you some wine?
That's correct.
You drink a lot, don't you?
I used to.
You've had a drinking problem, haven't you?
Yeah, in the past I have.
We can stop now, Your Honor.
All right, ladies and gentlemen, we're going to take our recess for the afternoon. Mr. Shipp, I'm going to direct you to come back tomorrow morning at 9 o'clock. Don't discuss your testimony with anybody else except for the lawyers in the case. All right? Let's have it quiet in the courtroom, please. All right, ladies and gentlemen, please remember my admonition to you. Mr. Shipp, you can step down. Go ahead. Ladies and gentlemen, please remember my admonition to you. Don't discuss the case amongst yourselves, form any opinions about the case, have any contact with anybody from the outside, allow anybody to contact you, and we will see you back here hopefully bright and early 9 o'clock tomorrow morning. All right, have a pleasant evening. All right, let's clear the courtroom for the jury, please.
For conflict. I'm sure he would not do it, but I asked his name be taken off. And I will further call his office and let him know that his name is off the list.
All right. And Mr. Simpson, it's my understanding that Mr. Robert McNeil has not represented you. He has not appeared on the record in this case thus far. That's my understanding. Is that correct? All right. And you understand what the problem is?
Yes.
All right. Great. Okay.
Thank you.
All right, one other thing. Ms. Clark, I need to do some planning about our visits out in the field. Can you tell me when you might be planning that?
Anticipated that we would ask for a jury viewing of Bundy just after the first officer on the scene testifies. That will come up. I'm reviewing the witness list. That will come up after the testimony of the witnesses from Mezzaluna. And that, so we'll have, it's not going to come up until after. How long is this going to
We talking a couple weeks?
vary? I think so. I think so.
Okay. Then, counsel, would each side has agreed that this is something necessary, the view of the scene, both at Bundy and Rockingham, both during the daylight hours and again at night. And my proposal was that we go there once in the daylight hours at the beginning of the case, and then towards the end of the case go back again during nighttime hours, which may get us right about June.
Certainly hope.
So we may even get the right time and moon and sun and the stars and all of the above. The sheriffs are putting together a travel itinerary, and we, of course, have to form a press pool to go along with us, otherwise they'll hound us. And the itinerary that they have planned so far is Bundy, drive by Mezzaluna, and then up to Rockingham, roughly, although they have a secret route. Okay, but if you want, would you give me the itinerary of what you think we need to do, and then, because I'll have to plan how long it's going to take us. We can't all go through these places together. It'll probably have to be, because of the narrowness of some of these places, maybe 3 or 4 at a time, escorted by deputies, et cetera.
Did you say, Ms. Clark, on that would be?
I thought at best 2 weeks, probably longer.
All right.
and we do Rockingham and Bundy on the same day. Because we need to, of course, we need to advance regarding Rockingham, so everything's also available. I think that's going to take care of Bundy.
Right, we'll take care of Bundy, but I wasn't anticipating doing them both on the same day, Your Honor.
Rather than take all the trips, I'd like to do Rockingham and Bundy on the same day, at least during the daylight hours. Makes sense.
I think it makes sense to do it all at once because they're all within relatively close proximity.
Then if we go back to night trips, we can do them both at night. We make the trips that.
Right.
Oh,
Let me just ask one other thing. Are we going to need to see the interior of the Bundy address? Is there any reason that we need to go in there?
I really, at this time, don't think so, Your Honor. But the court has asked me to,
You think so?
Yes, I think so. I think absolutely.
what's the relevance?
There's quite a bit of relevance. This instance where
Actually, if we get to the 90th, no, but that was at
That was Gretna Green.
Gretna Green, no, but I still think it's very relevant, Your Honor, because of all the things that the LAPD didn't do among other things. So I think it's very relevant. Not only to see the outside, but the inside, where the children were and that sort of thing. It becomes very relevant as we have these witnesses testifying about things that they heard.
Okay. Well, what I'm asking is, why don't you each side put together a list of what it is you want to see, and then because the sheriffs have to know timing-wise how long it's going to take us to do all of this for planning.
And I would like to be heard on the subject matter of taking the jury inside the Bundy residence.
Yeah. Well, think about it.
Okay. I'm not going to fight about it if we don't have to, but it doesn't seem relevant to me at this time.
I mean, if we're there and something comes
I
up.
think it's very relevant, and I'll talk to Mr. Clark.
Okay.
I'll convince him. John, I'd like to inquire of the people. Now that we're finally in trial, and Ms. Clark said something the other day about them concluding that case within 4 to 6 weeks. I think I heard that from somebody. I'd like to get a realistic estimate because we're kind of in a situation where I'd like to know how long these trials will take. And may I have just a second? All right.
Let me suggest this to you and Ms. Clark. Why don't you all, since we have some additional time this afternoon, why don't you sit down and formally chart out in blocks where it is you think you're going to be in the next couple of weeks?
I think there's something we can't represent to you, Your Honor.
All right. Ms. Olson, I thought you were leaving.
Something first with you.
Estimate, Your Honor, that counsel should be ready to proceed at the beginning of April, giving extra lag time for things that may occur like illnesses, excessive amounts of.
That's 2 beepers I own.
Take it.
Deputy Magnaro, would you take Mr. Darden's beeper, please?
Oh, geez, you didn't take these other people's beatings and Mr. Bailey's.
No, I
right.
said any other
You didn't take-
electronic
you didn't take
devices. I
mine?
took one from Court TV last week. That's 2 I have now.
Taking
It's a beaver company, since beaver, a newer, better model. A cellular beaver,
Taking the cut.
a digital. How is Ms. Clark going to get in contact with me tonight?
Your Honor, you have just hamstrung the prosecution in a very serious way.
It's life in the big city, Ms.
May I
Clark.
be excused the first?
You are, Mr. Darden. You may thank me for that, Mr. Darden. All right. End of April?
No, beginning
Beginning of
April.
April. All right.
And I'm giving this is very approximate. I don't know how long cross is going to be. It's very hard for counsel, for Mr. Cochran and myself, to estimate the DNA length of time for those hearings, that testimony. So this is a very rough estimate, and I can't, please don't hold me to this. I'm doing the best I can, but I really don't know. And cross does vary. I'm unable to predict how long they'll go.
When do you anticipate we'll see Mr. Hodgman back? If and when?
I don't know, Your Honor.
Okay. All right, counsel, anything else?
I think that we agree try to shoot for April 1st, at the beginning of the defense case, Your Honor. And give or take, as you said, the DNA, it's going to be interesting. Your Honor, is it possible, I have a brief hearing tomorrow morning. Is it possible that we could have, it's going to start at 8:30, is it possible we can start at 9:15 tomorrow? It's down in Department 111. Apparently, they held it today, and until 8:30, I'd like to have it 9:15 at least tomorrow morning. Is that possible?
9. Ms. Clark, you agree with that request?
She won't be able to in anyway, Your Honor, so it's okay. So it works out
I knew
fine.
he'd say that. I knew he would say it. No objection.
All right, 9:15.
Thank you.
All right, counsel, thank you.
Thank you.